could get it. You snoring.
Hey guys, do you like Disney Plus or TV shows like Stranger Things? How would you like to be on one? Be one of the first 200 people to sign up now, and the next superstar.
Which mean come on.
I've listened to the jail call from yesterday, and I've looked at the orders, and Ms. Weaver's just provided a rough of the transcript, so I'll take a look at the transcript and then get back to y'all on that. Good morning. I'll see what I think after I read everything. Okay. One thing, and I don't know whether this got resolved, but I noticed that there was an email at some point that was asking about a couple of states exhibits that might be the same thing, and I don't know if we need to deal with that or if you've already dealt with it. 430Y and 437Y, which were videos. Is that still an outstanding issue? That may be something we covered yesterday. Mr. Steele did, or somebody from his firm. August 8th. I mean, these may be exhibits we dealt with yesterday or the day before anyway. I just have been kind of marking things in emails that we need to cover, and want to make sure this got covered. Morning.
Thank you for yesterday. I would have sent that email, but I don't remember my saying email. You let me see it, or just tell me?
I mean, it says it appears the state's exhibits 430Y and 437Y are the exact same video. Shows Mr. Sledge, Mr. Jeffrey Williams, Mr. Shannon Stillwell, and others in-house talking over each other. Mr. Sledge flashes money. And I don't know who you're talking to then, but it says, can you explain why either proposed exhibit is admissible and why are there two proposed exhibits?
I think we dealt with that, not yesterday, but earlier this week.
I thought so too. I just wanted to double check before I cross that off my list. Okay. All right. So do we want to do the other? Were there any issues with the other CAD reports that are in the second Sharon Ladner folder?
Your Honor, I have not received any objections from the defense counsel related to
Okay.
the exhibits in that folder.
Are there any? It would have been in the group of 31 through 60 witnesses and the counts 3 through 7 folder, the Sharon Latner folder within that.
Judge, I didn't see any issues with the CAB report
Okay.
that haven't been previously discussed. However, I'm still obviously going through them again, but I didn't see anything.
Okay, well, told y'all to do that last night and bring them to my attention today. Okay. All right, I'm gonna assume then that there aren't any objections to any parts of those CAD reports.
Understood.
All right. And were we going to come back? I can't remember, we were to the Jean-Pierre social media. Is that because y'all needed a chance to look at that?
Good morning, Your Honor.
Morning.
I believe that I was going to narrow down which videos we were going to
Okay.
use. And I did narrow them down, but what I did not do, and I will do that now, is email over the timestamps that we think are relevant that we plan to introduce, so
Okay.
that defense counsel can take a look at it and we can talk offline if there are any objections.
Okay, did you get that finished last night or this morning?
I finished viewing it last night. What I did not do was email the timestamps.
Why did you not? So that they could have a chance to look at it before court.
That was on me, right? We were working on some other items, and so I just
All right, can
I
you
had to find them, so I will send those.
try to, like, when I give you tasks that you're supposed to do overnight, so that we can discuss them the next morning in court or the next day in court, please communicate across the aisle to the other side so that they can also be prepared.
Yes.
Thank you. It's not unreasonable. And then we were gonna come back on counts 27 through 29 to something with Smith. I can't really decipher my notes sometimes. What was that about?
Perhaps, Your Honor, this is something that I brought up about the videos. I knew that there were several videos of co-indictees that are not sitting for trial, doing live streams and kind of broadcasting things to the world about this alleged crime that none of us are charged with.
Okay,
And I raised some concerns. One of them, I understood that the state had a video of Mr. Beebe wearing a trap commander chain, but I was suggesting that maybe a still shot would.
yeah, y'all, the state would, thank you. The state was gonna narrow those down and figure out which you wanted to look at or which you wanted to use and which you weren't.
That's what I just addressed, Your Honor.
Okay.
Those are the timestamps. Those are the 3 videos that we looked at. We have identified the relevant timestamps of those videos.
So that's all the same thing, the Jean-Pierre social media and that's within count, okay.
Yeah.
All right, very good. Okay, and then I think the next thing we were gonna tackle was the, whatever co-conspirator statements or other supposedly admissible statements there were within the wiretaps. Is that what we were doing next?
We were doing that, and then we also wanted to see if Mr. Steele and Mr. Adams could identify which jail calls that.
Oh,
which
right,
Kenneth
yes,
Cole
thank
ran.
you,
Yeah.
as kind of first thing on the agenda. So I think maybe Mr. Steele, you had provided as reciprocal discovery some possible jail calls that maybe Mr. Copeland was a party to.
Yes, Your Honor. Did that in October, on October 25, 2023. I served on the state. They served on me numerous jail calls.
Okay.
I served on the state. They did not serve on me any jail calls from Forsyth County Jail.
Okay.
So I found out Mr. Copeland was housed there. There's approximately 163 jail calls from Forsyth County. I served that on them 11 months ago, maybe, whatever that comes out to. It's only a 3-week period. from February 16th, 2023 jail calls to March 7th, 2023. And I am narrowing what I'm going to use
Okay,
on the cross-examination of Mr. Copeland. Also, the state served on me huge amounts of jail calls of Mr. Copeland. So I'm going to, I believe, use some of what the state served on me.
okay,
And I'd rather not serve it on the state until they are done with the witness, because I assume that then the state will just take my cross-examination from me. So I'm not trying to play gamesmanship. I didn't have to serve any of those jail calls because I would never use them in my case in chief. It's just on a cross. I'll do whatever, obviously, you tell me to do, but if I serve it on the state and then they use it on their direct, I don't really see the purpose of me just giving away impeachment evidence.
okay,
In addition to that, there are not going to be many jail calls to listen to. And what I plan to do is, once the state surrenders the witness on direct examination, I would get all my exhibits to the court, to the state, to the court reporter, like I said, and the jail calls, I won't use them for a while. My cross, I believe, is going to be lengthy days on Mr. Copeland.
okay,
So, they'll have plenty of time, in my opinion, to listen to the jail calls. And I'm talking about a total of maybe 10, 11, maximum, maybe a minimum of 2 or 3.
okay, so you'll provide that, which jail calls you're gonna use at the beginning of your cross,
Yes.
okay. All right. So then, let's move to tackling this wiretap evidence. And where would be the best place for us to all look, so that we're looking at the same, or listening to the same thing?
Mr. Atkins served on the court and the defendants, I believe, a Dropbox link that contains these calls that we've identified, and they are in order of the way we would be addressing them.
Okay.
So we can resend the Dropbox link if anyone needs it.
Is it the August 8th one, or is it a different one?
I think
It's a different one, Your Honor.
Okay.
I will pull up the date. It's the co-conspirator Dropbox that was on a Friday. Give me 1 second.
Okay.
he is.
Your Honor,
Yes,
while that's being done, can I ask the court of inquiry?
sure.
Mr. Adams is, I'm assuming he told you, but he's doing another matter, which is no problem for myself or Mr. Williams. But at approximately 1:50 to approximately 3 today, so an hour and 10 minutes, I have to be, with the court's permission, on this case, but have to be outside your courtroom. So I can't believe I can say this, but my wife is going to sit in
Okay.
with me, and that's okay with Mr. Williams. Is that okay? Colette comes. And her name is Colette, Colettete, Steele, Steel, if that's okay.
Yeah, that's fine. She's been in my court before. That is fine, as long as somebody's here.
Thank you.
All right.
And that link has been resent to all parties, Your Honor.
Thank you. All right, and would this be in the folder labeled additional co-conspirator statements, or where do we find it?
470 and it ends in 7355.
Got it.
And it has the wiretaps. They're saved, so we're going to be using. It stands for PDF page because the report that they generated was a 6,000 page PDF. So we will be referencing, for example, the first one is PDF page 17. So at the bottom of the D. Garlington wiretap folder, you'll see P17 and then 11 March 22 at 10:05 p.m.
Okay, thank you.
Yes, Your Honor.
And Judge, what I'll do is I'll do whatever the court says, but what I'm suggesting is that I give a summary of what we're about to play, tell the court the timestamps, and then play them unless the defense wants to just tell us in advance what they object to, whatever the court says.
Okay, well, if we don't need to listen to all of them, there's no reason to listen to all of them right now. So does the defense know which ones they're gonna have objection to?
How about all of them? But I don't accept, there is a summary, a state summary in the exhibit that you just got forwarded by Mr. Atkins, and I appreciate him outlining that. I do, and that makes it much easier for us to go seriatim through the wiretaps. But the summaries are in large part partially accurate. They're not fully accurate. So I'm confident that a number of us will object to all of this. And for the court's information, I don't believe any of the people on these conversations will be testifying. So in that regard, I think we need to go through them item by item.
Okay.
We didn't intend that the summaries be pushed.
Okay, I don't actually, the bottom of mine is 20 March 22. I don't see an 11 March 22. Unless it's not the actual bottom.
It's at the top of the calls on the Dropbox link, page 4. For different people.
Yeah, that's fine. I think what Ms. Persfield saved for me separately may be in a better order. Okay. Okay. Yeah, I agree here. All right. I mean, if you're gonna play them, I don't need to open them anymore. Separately, yeah. Okay.
And if your honor would like that, we can resend it.
I definitely can find it if it matters. So I found the email that has the wiretap calls guide and call detail reports. Is that what y'all are referencing as a summary, or is there something else?
Your Honor, there's a separate Excel spreadsheet that Deputy Hilton sent to the parties that we will resend.
Oh, Miss Hilton, okay.
Yes, Your Honor. It's highlighted in yellow.
It come from, yeah, somewhere.
And that came on Sunday at 1:30.
Yeah, no, that's fine.
All right, go ahead.
So the first one is gonna be the call that is labeled page 17, 11, March 22. The time stamps that we'll be playing is 27 seconds in through 3 minutes and 25 seconds.
Oh, that shit was Chris man.
Yeah, man.
That shit, that was crazy, what?
I've been going through one call when I had them posts. He told me, "Tell Corey," I said, "What's wrong?" I told you that.
Yeah, that one I got that on like that shit, that just too crazy.
But that's a fool. Boy, I was like, damn, boy.
They need a little more of this.
I don't know. I think he the one that got shot in the head. I don't. Like, everybody been said he had died first. Like that's what they were saying at first. They were like, brothers in critical condition for him. And
I heard him hit in the head.
yeah, but Roger had they got them told him what had down. He had that DM. They were like, man, brother died too. So we turn on the video chat shit. But he was like, Roger said he came from Summerhill, but Quay said they got into it with when they was at chit chat, they got into it with them henchmen. They,
Who nigga?
man, look, I think them niggas all I rent them folk, man. You know,
Oh, yeah,
own phone, they going back and forth, they gonna answer.
They all I rent?
Nah, not him, but like his little young nigga.
Oh yeah, I heard it like hits me shit.
Yeah, Quay say when D Slime just had the show, on D Slime, them got down, rushed to the car to get a fire, some shit, they had gotten to it.
Yeah. They crazy right now.
My cousin they called him something, he you know what, he told me to pull up, he got down, you know what happened.
Yeah.
I'm gonna pull up, got down, see what the heck going on.
So what yeah, you walk coming from the court?
Yeah, man, that was a little core, man.
Oh yeah, so I thought it was traffic or something.
Yeah, that's what I thought, cause everybody went to traffic. You like I be telling them they go to traffic. I ain't even saying that to him last night, I said put their clothes on.
Looted at 5 in the morning.
Yeah,
And like somebody got shot in the car. But they ain't really showing it.
yeah.
On Instagram, I'm like 6, 7, I'm like 7, 8 up or something. Damn, they went to war.
Yeah, man. I ain't know them folks doing these phones up.
Y'all, them folks like, them folks were on one. Them folks, they ain't seen none of them niggas in the bar.
Nah, man, yeah, it was just them two, I think. I don't know. I ain't heard nothing, bro. I ain't caught nobody.
Man, they niggas running, man. What the hell wrong with these niggas, man? They walk so goddamn fast.
I ain't talking nobody with LB.
Oh, AV.
Yeah, you know he don't know.
Yeah.
Yeah.
Well, AV just laying low.
Nah, he with his folk.
Okay. And the girls in charge, man, call their phone, somebody, this ain't his number. Yeah.
For real.
Yeah,
Yeah. Yeah.
Okay. And when the hell you been doing? You got perk?
Man, I ain't got nothing, bro. No weed, no perk, no nothing. Tay finna got down, 21, nigga, he finna got down. He said he just called this boy, he wanted nothing to get back.
Oh, okay. What they supposed to be want for the week?
No, you know, he just spoke got down 26.
Oh, yeah.
Yeah.
Can't beat them right now.
Yeah.
Judge, this call was made on the day that the two persons who were YSL associates were killed, Mr. Ford and Mr. McMiller. It was after that. What we've heard is a call, as the court is aware, from Mr. Garlington's wiretap, where he is talking and apprising an associate, unindicted, unnamed co-conspirator, whom we believe is a person called Dwoskin Watt, right? W-R-I-G-H-T. We believe that he is a 30 deep member. Nonetheless, regardless of who it is he's talking to, that person is an unindicted co-conspirator as well. In discussing what has just happened, they are alerting one another to something that has happened to one of theirs, and they are letting each other know what, for instance, Bonk and Big Slime did, in that they rushed to the car to get the fire. They had gotten into it. My cousin had told me he just pulled
On February 22nd, 2022, another YSL associate, Christian Eppinger, reached out to another YSL associate, Antonio Summer, to get permission to finish off what Jaden Myrick did not do. That information about Mr. Bennett being stabbed in the jail in February hit the media sometime early March. I think maybe around March 3rd or March 4th is when that information was released to the media. On March 11th, in the early morning hours, that is when Christian McMiller and Darius Ford were murdered. Pending that release, we believe that they were murdered by Wyatt Associates. We have shell casings from the murder scene, match a shooting that happened on March 16th that I'll get to in a moment. After the shooting of Mr. Ford and Mr. McMiller in the early morning hours on March 11th, there was another shooting on March 12th in which a YSL associate, Stephen Harris, shot at in the direction of 12 Atlanta Avenue, which is a YFN stronghold, hitting a YFN associate. His name is escaping me at the moment. Following that, there is a call that the court will hear in a moment, in which there's a shootout on Cleveland Avenue, in which Demekion Garlington and I believe Mr. Stillwell are involved in the shootouts on Cleveland Avenue. Following that, in the morning hours of, I believe it's the 13th of March, it might be in the early morning hours of the 12th of March, there is a drive-by shooting near 2830 Waters Road. This is what we believe is the trap house of Big Nick, who is, I think it's Nicholas Carter, forgive me on the last name, but he is a YSL associate. Following that shootout is when there's some social media postings, Your Honor, in which Shell Kel, who you've heard of, Kelvin Watts, repost a picture with Shamel Drinks, Kelvin Watts, and another individual that could have had some subliminal messaging that they were the persons responsible for killing Christian Miller and Darius Ford a few days earlier. Those posts were posted around between the 12th and the 14th, Your Honor. Also, there were some other social media posts from YSL associates, basically claiming they are not going to be the only ones crying tonight, things of that nature. Then we had the murder of Shamel Drinks on March 14th at about 9:55 p.m. in the evening. And then following the murder of Shamel Drinks, we had on March 16th in the early morning hours around 12 o'clock a.m., another drive-by shooting at 2830 Waters Road, where you will hear some wiretap calls of Mr. Garlington, Mr. Stillwell, and Mr. Farley actually at the house during the time of the drive-by shooting, or immediately after the drive-by shooting. And then Mr. Stillwell and Mr. Nichols are apprehended on March 17th. So understand that timeline. A number of these early wiretap calls are going to come into that time period with when all those events are happening. Go further and go into the conspiracy. Thank you.
Protected like frozen critical condition for it. And
I heard you hit the head.
yeah, but Roger had they got them told go ahead and help. Yeah, and then they were like, man, brother died too. So we just turn on the video chat shit. But he was like came Roger said he came from Summer Hill, but Quavo just said that they got into it with when they was at Chit Chat, they got into it with them henchmen. They,
Who nigga?
man, I think the niggas them folk, man. You know,
Oh, yeah,
from they going back and forth, they gonna answer.
He going out right?
Nah, not him, but young nigga.
Oh yeah, I heard it like hit me shit.
Yeah, Quavo say when B Slime just had the show, from Slime, they got down, rushed to the car to get the fire, some shit, they had got into it.
Yeah. They crazy right now.
My cousin, they called him something, he told me to pull up, he got down, you know what happened.
Yeah.
I'm pull up, got down, see what the heck going on.
So what yeah, you walk coming from the car?
Yeah, man, that was a little cord, man.
Oh yeah, so I thought it was traffic or something.
Yeah, that's what I thought, cause everybody going to traffic. You like I be telling that nigga they go to traffic. But I ain't even saying that to him last night, I seen him putting clothes on. Okay.
I remember this mom up at 5 in the morning.
Yeah.
And like somebody got shot in the car. But they ain't really showing it.
Yeah.
I get on Instagram, I'm like 6, 7, I'm like 7, 8 up or something. I'm like, damn, that went the war.
Yeah, man. I ain't know that no folk be on the phone no.
You know what I'm saying? Them folks like, them folks were on one. Them folks, they ain't see none of them niggas in the car.
Nah,
Like,
man. Yeah, it was just them two, I think. I don't know, I ain't heard nothing, bro. I ain't called nobody.
Man, that nigga running, man. What the hell wrong with this nigga, man? That nigga walk so goddamn fast.
I ain't talking nobody but Ed B.
Oh, Ed B.
Yeah, you know he don't know.
Yeah.
Yeah.
So Ed B just laying low.
Nah, he with his boat.
Okay. And the girl in the charge is screaming, man. Cloud their phone, somebody, this ain't hitting no. Yeah.
For real.
Yeah.
Yeah.
Okay. And when they even do that, you got perk?
Man, I ain't got nothing, bro. No weed, no perk, no nothing. Tay finna got down.
I just stopped it at the 3:45 mark.
All right. All right, both of the speakers seem very familiar with who the people are, and it may not be I'll give you, they don't seem to be plotting any retaliation in this call, but they do seem to be getting apprised of what's going on. And it be an all-out war and things like that. So I'm gonna permit that under the co-conspirator exception.
Can I, Judge, on behalf of Mr. Nichols, I'm gonna join in to each of these, and I may have something additional. I do want to say that for all of these, I don't know whether the state has established that there was a conspiracy that existed, which is the first element of any admission of 801D2E purported statements. And I think what I heard in this, although a lot more was played than was in the spreadsheet, and I understand that may have just been a mistake, but I heard a lot of "I think" and "who is that?" And it sounds like I got that on Instagram. So I want to have a continuing objection, and I'll object again when it's appropriate, to what's commonly referred to as nested hearsay, which is somebody saying what somebody else said. It's hearsay nested within hearsay. So I don't know whether, well, I don't agree, of course, with the court's ruling. I'll abide by it, but I think there's more to it than just they're telling them what's going on. I think they're telling them what they heard, what's on Instagram, and I want to make sure that this quay, somebody said quay, not qua, or qua, but quay, and I think the response was, "Who's that?" And then they talked a little bit about that. That is not Mr. Nichols. And if there is any dispute about that, we can go into that further.
All right, well, with regard to the nested hearsay objection, I don't think that what got posted on Instagram or anything like that, that might be nested. It's only hearsay if it's being offered for the truth, and that type is not, I think, being offered the truth. Is that correct, Ms. Love? It's being offered to show that they are trying to keep apprised of the latest that's going down between these rivaling factions. So overruled. And I mean, yeah, it certainly sounds like quay to me. And so if there's going to be any,
there's not going to be speculation unless someone decides he wants to tell who that is. There's not going to be any speculation about who quay is or
all right,
assertion that is.
okay, let's move to the next one. And then y'all give me kind of the rundown of what I need to be listening for and why you think it's admissible under a co-conspirator exception before I listen to it.
The next one that we're going to play is the call on page 25 from March 12, 2022. And this is a call that speaks to the portion of the indictment regarding the sale of narcotics to support the enterprise. And on this call, Mr. Garlington is on the phone with the female who is asking, "Where are the people with the perks?" Mr. Garlington's response is, SB says he has no more. Everybody in the studio just wants some. Everybody in the studio wants some. They just bought him out. I'm going to let the court hear it. That's just a summary of what we have, but in terms of,
And that's what counts of either the indictment or overt acts.
it's count one more appropriately looked at on page.
So it's not a separate count, it's just an overt act.
Right, but under
Okay.
part one, the conspiracy, if the court, in both the body of the count itself and underneath the description of the conspiracy, where we list obtaining money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs.
Your Honor, to address your question, in overt acts or substantive counts, neither Mr. Stillwell nor Mr. Garlington are charged with distribution of drugs. That's nowhere in the indictment.
The conspiracy is described as that.
Where? What page of
Page
the?
12, I believe, if you have it labeled the way I have it, but it is directly under count 1, after the names are listed and after the statute itself is described, we have in the indictment part 1, the conspiracy, and if the court looks at the 4th bullet point under the paragraph labeled part 1,
All
the
right.
conspiracy.
Okay, let's see what you're talking about. And then, do you have overt acts that are?
We do have some that are drug related,
Okay.
not one that describes this particular transaction, but we have some that are drug related. I want to be clear.
Where are those? Which numbers?
I'm sorry, act number 3, possession of marijuana with the intent to distribute by Shannon Stillwell. Act number 8, possession of cocaine with the intent to distribute by Antonio Sledge. Also in the counts themselves at the very back, we have count 60, Martinez Arnold, Diamante Kendricks, Jeffrey Williams charged with possession of cocaine. They are also charged with.
It's just possession of cocaine doesn't get anybody any money.
Violation of count 59, violation of the Georgia Controlled Substances Act, possession of codeine with the intent to distribute, count 58, violation of the Georgia Controlled Substances Act, possession of marijuana with the intent to distribute. They are charged with gang activity, to wit, possession of marijuana with the intent to distribute, possession of codeine with the intent to distribute.
All right, and so this would be evidence simply of the pattern of racketeering activity by members of the alleged Rico enterprise.
Yes.
Okay.
Your Honor, I'll point out that these are different individuals, different types of drugs,
Mm-hmm.
and from absent the count that the count involving Mr. Williams from 2022, those other examples of drug-related overt acts are from approximately 9 years before this wiretap.
Okay.
And Your Honor, the counts, the substantive counts that you just referred to, they're all on May 9th, 2022. You should know that's the date that Mr. Williams was arrested. His home is met.
Tailgates are better with Sam Adams Oktoberfest. Maybe I am a morning person. It's Sam season!
Found several people who lived at that home. This was not a.
I mean, I understand very clearly that the state's alleging this and the state's proving it as, I understand. People have drugs. They may be illegal, but people have drugs. People have parties. Sometimes people have a lot of drugs. And establishing that you've got a lot of drugs and establishing that you are intending to distribute those drugs to garner additional money for your alleged enterprise are two entirely different things. That'll be up to the jury to decide. They can offer their proof. I mean, that's not what I'm here to decide. I'm here to decide, is it admissible under the rules of evidence? So I hear what you're saying. You're gonna have to tell that to the jury. That's not up to me. All right, so, so I understand the purpose for it, so let's go and hear do we know who the female is?
We do not have information definitively.
Go ahead.
Based on the information that we received from investigator Viverito, the female may be a young woman by the name of, I don't want to give her whole name, but her last name is Jones.
Okay.
And she is the mother of one of our defendants' child.
Okay.
So in terms of the portion that we're playing, we're starting at 51 seconds. Zero, 51. I'm sorry, going to 51 seconds, starting at the beginning of the call.
Hello. Huh? Where the nigga with the perks? And you say he ain't got no more. He don't got no more. Yeah. We at the studio. You might go. I'm outside the studio. You just said you run out then. Right. That's why I said where you going. So you don't know nobody else that got some? Everybody in the studio just had some song. They just bought them out.
And I stopped at 52 seconds, but it was just after he said they just bought them out.
So, whether it proves it or not is yet to be determined, but I'll permit that under a co-conspirator exception to hearsay.
And for the record, Your Honor, I would also argue not only is this not part of any conspiracy, but also that Mr. Garlington informing someone that Mr. Stillwell is out of pills is not in furtherance of him selling pills.
No, but it might establish that it's something that he typically does.
I understand why the state wants it in to show that my client's a drug dealer, which is why I want it out. But the hook for admissibility is that it's in furtherance of the conspiracy, as I understand the law of co-conspirator statements, and I don't believe it's in the furtherance of any conspiracy.
What is the state's response to that?
That in asking for the pills, where are the pills, and in giving the information that the studio, they just bought him out, they are furthering the conspiracy by requesting more to be re-upped and getting information about where they are in terms of their supply. This furthers the conspiracy, that aspect of the conspiracy wherein they sell or distribute narcotics to gain money, weapon, or other property through racketeering activity, including the unlawful sale and distribution of drugs.
Well, that doesn't work for 801D2E. The declarant needs to be part of the conspiracy. Someone requesting pills, Mr. Garlington, is not in any way, under any argument, cannot be part of any YSL conspiracy. A buyer and a seller are not part of the same conspiracy. And so we have an unknown declarant who's seeking to buy pills. The state is seeking to admit their statements as part of a conspiracy. And I don't believe that fits under the hearsay exception.
Your Honor, the conspiracy is not the interaction between those two people. The conspiracy is the broader conspiracy of the YSL enterprise and what and how they conduct their operations. So in as much as they sell and distribute narcotics to gain property and other activity, the conversation wherein Mr. Garlington is attempting to gain more narcotics, or this young woman is asking where the perks at. She's trying to get narcotics from a YSL member, and Mr. Garlington is saying that Shannon says, or SB says, he doesn't have any more, but everybody in the studio wants some. They just bought him out. If the court considers the Georgia Supreme Court's liberal standard applied to determining whether or not their statements in some way further the conspiracy, the statements can be construed to mean we're trying to re-up. I'm apprising you, this girl who is also, we would argue, and unindicted she is in the sense that she is participating in the drug aspect of this larger conspiracy. She is participating in an effort to continue the sale or distribution of drugs within the YSL enterprise.
Okay, so, I mean, I think it does show that Mr. Garlington is involved in, has knowledge of SB's supply chain and when he has it and when he doesn't, and what has just happened. They've just been bought out. I'm gonna permit it. Again, whether that's an ultimately successful and convincing argument is for the jury. You may.
And for the proposition that buyer and seller cannot be co-conspirators, it's Darville, DARVILLE, the state 289 Georgia 698 at 715. It's a 2011 case.
All right, but it doesn't appear that Mr. Garlington is a buyer or a seller right now. He seems to be kind of a middleman for communication. So if your argument's he's a buyer or a seller and it can't be both the buyer and the seller, that's not who's having a conversation.
No, my argument was that the state's seeking to get in the words of this young lady who is clearly a buyer. And if we're saying that YSL is a set of sellers, a conspiracy of sellers, she cannot be a conspirator with them. And that's my argument.
Okay, well, I'm admitting his statements under the co-conspirator exception, and hers would just be to give context to what on earth he is talking about.
Your Honor,
Yes.
understanding the court's ruling, can the record also show that you consider that this is spilling the beans and it's not in furtherance of the conspiracy, because all it's doing is saying the person doesn't have something that does not further the conspiracy. It's not like he is going to rob someone to get the drugs. So I just asked that the record show we're not waiving that issue.
All right. Thank you.
Your Honor, the court,
Mhm.
and I wasn't certain whether Mr. Steele was asking the court to find that, or if he was just saying that that was their objection. I just wanted that clarity. Was
Well, I'm
he?
sure he would like for me to find that it wasn't in furtherance of the conspiracy. So yes, I do think he's asking that. He's objecting on that basis.
Thank you.
Understood. Making the record clear.
Thank you.
All right. What's the next one?
The next call is on page 40. This is Mr. Stillwell speaking with Mr. Garlington.
And what's this going to be about?
And in that particular call,
Okay, I mean, I think the summary provided by Ms. Hilton gives me enough context for this one. Okay. All right.
so we're gonna go from the beginning of the call to 1 minute and 12 seconds. It's a 1 minute and 46-second call.
Yo,
What the hell you got going on?
shit, you got up?
Anybody asked, we went, looked like soon, and midnight, anybody just said we went and looked for them motherfuckers.
Okay.
I said nobody.
Yeah, I know. Well, what do you got?
Even wrong.
Even wrong.
Shit, same shit.
Same shit.
Same shit.
What's that? What do you
Sometimes they gonna come pick me up. Shit, that was on.
Yeah. Yeah.
Thanks a lot. He here on Rod. Look, I said, man, Rod, I ain't no cold.
Yeah.
I tried this shit yesterday with a nigga on that now.
Yeah.
Yeah.
I've stopped it at 1 minute and 14 seconds.
What's our argument against this one?
Mr. Stillwell is apparently on the recording, or what's alleged to be Mr. Stillwell saying, but I couldn't find it. I don't know what the state's theory on how this advances a conspiracy, I can guess, but the pronoun it doesn't make a lot of sense to fit their theory. So, I don't, from the context, I don't see how that could be in furtherance of a conspiracy. That seems just like talk, which we obviously aren't privy to the conversations that these gentlemen have offline, which would provide context and context that they have it with each other, but that's my objection.
So, Your Honor, we believe this is a party opponent statement of Mr. Stillwell, but from the state's reading of this call, they're trying to do a drive-by shooting, but they can't find the op, just to put it plainly. And then when they're asking, when one is asking what you're getting into and the other one says the same old shit, the same shit, essentially they are apprising one another of their efforts to shoot an opposition gang member.
And I don't know whether it says it or him, but
Right.
regardless, I mean, the whole context of it, you can tell that's exactly what they're talking about is what Ms. Love just offered, gonna admit it both as an admission by a party opponent and under the co-conspirator exception.
May we have a continuing objection to all these?
Sure.
Thank you.
Yeah, I mean, I understand that just because I'm ruling against y'all, you are waiving your objection. Unless, and I still understand it, but do you mean you're now not gonna voice objection to the rest of them? You're just gonna assume that I,
No, I was talking about
Okay.
at trial with the
yes,
jury
yes,
when these
of
are
course.
presented.
All right, next one.
The next one is page 61, March 12th, 2022 call. The applicable portions are from the beginning to
Man, shit. Yeah. What the hell you got going, bro? You alright? That's crazy, yeah. That's crazy. Main reason why I'm just standing in the house, man. What? That is crazy, but they ain't really even trying to. So why? Man, what? I was chilling. My brother's wife, I ain't that stuff. My brother brought me the house. No. Yeah, man. You know, goddamn, I ain't got that gun. You know, you need them. Call away though. Yeah, for sure. I would have you back. They told me, bro, it was look, I don't even know really in the paint. Who? The gun. But my mama took they were me and my brother in the car right now. Nigga, we couldn't read it now trying to see what the hell he said. Oh. That nigga, you talking about little Don? Nah, yeah, no. Are you talking about little Don? Yeah. Oh, wait, yeah, he might be serving or something. No. He like, all right. Yeah, no, good. You know what I'm saying? The whole, but I think the whole like 700, the whole 700, you know, I say, like, what you want to do? Like, what you want? Like, what you want to know? What you want to play like that? Man, what? Yeah, somebody called me and told me that shit. Like, I don't really fuck with who. Like, nigga, who? Man, the whole who everybody was just fucking with, man. What whole twin? Oh, Waco. I don't know, but I'm gonna holler at little Don about that. Yeah, I don't know tonight. What you want? Like, what you want to do about it? But you see it with your own eyes. No, they say we heard it. You know, I got down. You know, the shit like, you know, she thinks that down, shut it. And then set her up. Yeah, she thinks like they set her up, so she got down like. I usually want to play like that. Like, I know all the drunk shit. Like, I know all these drunk shit. So they were like, they heard. Yeah, they were like, they heard. And they were like, all right, what you want to do like the nigga did? Okay. I don't even know you. I mean, unlimited. Yeah. I call it in that thing. I don't know. I'm saying they call. Yeah, that doing no ring on my street, bro. Who the hell you gonna have for you? I'm telling man, be slow, man. Come on, man. Anybody that tone flows, you know how to do it. Yeah. I don't think you caught it there right now. Until that. Okay. Yeah.
If the court wants to hear from us first, I can, or. Go ahead. Okay. So, Judge, this call is one in which one is apprising the other of what's going on, letting him know. Mr. Garlington letting the other male know about things that may put them in danger. This person believes, one of the opposition members believe that Shannon and Pokey set her up. He's apprising the other male that he's talking to that this person is asserting they know where all the drops and the spots are, in keeping them, one another, co-conspirators, up to date on possible actions that might be harmful to the group. They are allowing each other to remain alert and ready for any action that may come as a result of what this person that they're talking about is doing.
Hear from anybody on the defense side?
Same objections, but I heard a lot of nested hearsay in this. There's speculation. There is, I heard it, they heard it. It's replete with nested hearsay, and we still don't have an identification of the person being called. So for all the reasons that we've said before, I think that this cannot be considered to be something that fits within the particular definition of 801D2E. And I just want to say that the courts have said, and I quote, "The proponent of the out-of-court statement is not entitled to a free pass. A judicial determination that a co-conspirator's statement tended to further the conspiracy must be supported by some plausible basis in the record. To that extent, the in furtherance requirement represents a real limitation on the admissibility of co-conspirator statements. Here, half of the conversation is by an unknown declarant. We do not know whether or not that person is part of this alleged conspiracy, or even a non-noticed and never noticed alleged co-conspirator. We asked for a list of co-conspirators in November of 2000 or December of 2023. We've never been provided that. And all of a sudden we get
This Friday. Welcome to the island.
There's something wrong with this place.
Uh-oh.
Let's go say hi to the guys. Better luck next time, bitch.
Blink twice. Rated R.
by an unknown declarant.
I'll add, Your Honor, that, and maybe I'm the only one, but listen to that. I mean, I understand that there seems to be general criminality maybe discussed, but as far as distinct, what they're talking about and distinct crimes, I'm a little lost when I listen to that. So I don't know how, if we don't even really know distinctly what they're talking about, I don't know how we could deem their subject matter part of a distinct conspiracy.
Stay where reply.
Yes, Your Honor, I think that the context of this call makes it clear that they are apprising and warning one another of possible harmful actions by an opposition member and keeping one another apprised of possible harm at the hands of opposition is a act that furthers the interest of the conspiracy. Conspiracy being the YSL enterprise, the criminal stricken and the YSL, in keeping their members out of harm's way. Share that type of sharing of information furthers their interest in knowing what the opposition is doing and is about to do, and they do some more.
All right, I'm gonna roll that that's admissible.
The next call is page 71. Demetri Darlington is asking Shannon Stillwell if he should bring the whatchamacallit, and way, the call on page 71.
The state in their lead-in, are they giving the court and us what they believe this is about, or are they quoting to a previous call that they're saying provides context? Because the state has declared like all of these facts, but I don't know if that's based in fact or just kind of their theory.
Judge, we give the court the reason that we believe that the call is pertinent and the reason that we believe it furthers the conspiracy. If there is an alternative interpretation made by anyone, then obviously that's an argument that they can make. But this is the reason that we're offering and attempting to have this deemed admissible. That's what the court asked us.
Okay, well, I mean, I'll listen to what's on the call. And we'll take a restroom break after this.
Yes, Your Honor.
Yo,
Let's come outside, bro.
hey,
Yeah.
Brandon Woodham calling.
I told them, don't bring it yet, bro.
Alright.
Yeah.
Is there more to that conversation, or that's just all we have?
That's all that there is to that call, but we have other calls during this time, and Ms. Hilton sort of gave the court the timeline, the reason that we believe that this call is referring to a gun. They're not wanting to say gun, and they are obviously arming themselves for what they believe is about to happen as a result of the fact that two of their associates have just been gunned down.
All right.
Because they're obviously doing this, obviously doing that. And I understand, you know, things are for the jury to determine. But my point, Your Honor, the danger of this is everyone sounds suspect when they're on a wiretap. I mean, that's, when you hear a wiretap conversation, it sounds suspect. And the reality is, later on in this, we're going to hear some more calls. And Mr. Stillwell talks about bringing things out wrapped in a towel, bringing things out, make sure it's white. And here's the thing, we litigated some things earlier. Mr. Stillwell was arrested in the middle of a sacrifice of a goat. And the backstory behind that is EFI religion and different practices involving that. We suppressed that information. There's in this, and I don't think I should have to argue this to the jury and bring up religion, but the reality is there's multiple references of bringing things in towels. And as part of that religion, there's a thing called elekes, and they're the beads. And they're not to be brought outside unless wrapped in a towel, and preferably a white towel. They're supposed to be wrapped, not exposed to the element or outside. So there are alternative explanations for a lot of these things, and it's just bare speculation by the state. And to refute that, I don't really want to get into my client's religion and all that. And I guess I will if I have to, but there was a reason that was off limits. And if we're just forcing me to present all that just based on bare suspicion by them and speculation, I don't think that's appropriate. I think we have to demand that they have some actual evidence of this is what they're talking about, and it furthers the conspiracy, not, oh, we think this is what they could be talking about. And that's my concern.
Okay, and it seems to me that the timeline that they provided is enough of the evidence to suffice. It's not in a vacuum.
And Your Honor, I would also say that we are pulling calls in an effort not to play all of the calls, because if anybody sat there and listened to them in succession, it would be even clearer than it appears at this moment what they're talking about, and anyone would be able to distinguish when they're talking about their ethos religion versus pulling out a strap or bringing a gun to go shoot someone in a drive-by. So we're pulling these calls to limit the number of calls and evidence that we're presenting to the jury, to make the trial more efficient. But the way that I'm hearing it, the only way that you know it to the satisfaction being asserted by counsel is if we play every one of the calls so you could see what it is exactly that they are and are not talking about. But we don't believe that that is necessary.
Okay, well, I mean, y'all try your case the way you see fit to try it. I'm gonna admit this over objection. Let's move on to the next one. Oh, sorry, we were gonna take a restroom break. Yeah, obviously don't need to find out, I'm still up there drinking water. All right, we'll take at 11.
They taking a quick little break. Remember to like, comment, and subscribe to Miss Spaz.
Power Crunch Protein Crisps. The high protein potato crisp in a variety of bold flavors to fuel.
Hang on. Here we're missing. You can go ahead and get it queued up. All right.
So, Judge, the next one we have on the list is 152. So 115 is one we'll come back to. We didn't have it on the list that Ms. Hilton sent. It's in the Dropbox link, but it's not on the shorter list. So we'll come back to 115 and just go skip to 152.
Okay.
152.
Yeah. I think maybe it seems like maybe the page numbers on this are maybe one off on a lot of these. So I think it's 150 on this, but for whatever reason, 152.
No, you're right. So the left column is the reference number.
Yeah.
Don't look at the reference number column. Look at the PDF page number column, which is the second column.
Honestly, so that I could fit it on one screen, I ditched some columns.
Oh,
so
okay.
whatever. I'm following you. Go ahead.
So, all right.
I'm sorry, I'm still a little bit confused. The call reference is 150 though, right?
It is, Mr.
Okay, thank you,
Harvey.
thank
Yes,
you, thank you.
So if you all would just ignore entirely the column that says, if I may, Your Honor, ignore entirely the column that says reference number. Look immediately to its right at the column that says PDF page number. And that is the number we will reference when identifying the calls. And we will proceed.
So when we were before the jury with these, there going to be any faster of a way for y'all to get these queued up and to the right part?
Yes, we have a graphics team.
Great, thank you.
Start at 4 minutes and 47 seconds in. We'll start at 4:24.
Well, good. I really like well, real good. Yeah. Bro, D, if you say about that, hey, for real.
Man, I'm DB on Saturday, bro. No, I
Bro. No, I said I ain't called you. A dad said, do you care? So I text, I ain't want to call you. He said, yeah, he after I called.
Yeah, that's what. Oh, that shit got me hurt, bro. I fucked bro.
Yeah, that shit put me on. So I know you said like that.
Hell yeah, man.
Damn, big puppy little shit too.
I know it, bro. Damn.
That shit crazy. That's why I said they had like 45 gun shells out there.
45 gun shell?
Yeah.
Just know, as long as you get that, we have to yeah.
D, you better show that down somewhere.
I am, but still, bro. I am gonna sit down and listen. I'm gonna sit down, bro. But
you better show that down somewhere, baby.
I am, but bro, niggas think this shit a game you out here playing. For real, bro. Like, I already going through some shit before that. Like, it like, all the time they trying to got money on my head, bro. Like, when I still just be going places, we still be worried about shit, bro. Like, I be prepared for shit. If a nigga pay me, they know this shit ain't gonna be easy.
Oh, man.
I just got to a shootout early.
Why the fuck you get to a shootout, D?
Because it was a car looking strange. And don't say nothing, man. You saying all the gun there.
Why would you? Oh my god.
Because the car, they were 3 deep with hoods on, so I had to shoot it on the day. It was the car, the day on Cleveland. On Cleveland, it was a car I know it, bro. Yeah, you do.
You need to,
Yeah. Yeah, you got to work. Yeah. That had they found it for he cool. Yeah, I would have. Mm-hmm. Hey, what's going up at 131? Yeah, I just thought it was pop. You just said, you know what we on every day. Hello? What's you going up at 131, bro?
I was asleep. They woke me up and said you were dead.
Oh, yeah.
I'm like, damn.
I'm gonna tell you something. I'm in the car, right?
I do say love.
I love you too. If you want to take me back, you're going on block. You heard?
Okay.
All right.
So, Judge, this one we believe comes in a couple of different ways. Obviously, it's a statement against penal interest that Mr. Garlington is making about him and Mr. Stillwell he is, as the young lady is apprising him that people said that there were 45 gun shells out there. He is telling her that they're gonna get some get back. There's gonna be retaliation. Those come in under that exception. The called party, it appears, is playing a role of support to Mr. Garlington as he is telling her what they are going to do. She's apprising him of the number of gun shell casings they said that they found, as he's telling her that they have money on his head and he's prepared for stuff. This isn't going to be easy. Telling her that he had just gotten into a shootout earlier on Cleveland again is a statement against penal interest. But in talking with her and in communicating with her, he is able to further the interest of the conspiracy this furthers the interest of the conspiracy in that he is able to lean on this person for the support that she is giving him through the course of this conversation. So our position is that it comes in, it's a couple of hearsay exceptions that it falls under. Co-conspirator statement and statement against penal interest. And it also is a reflection of Mr. Garlington's state of mind, his statement that they're going to get some get back. So it's sort of a reaction and a present sense impression.
Respectfully, I don't think the case law supports the lean on for support exception to the hearsay rule under 801 D2E. This is classic spilling the beans. It should be noted that Mr. Garlington says at the very end, I'm drunk as F. So he's intoxicated, he's talking to a girl, he's likely boasting, trying to seem tough for his own personal reasons that have nothing to do with the conspiracy. And it's not furthering the conspiracy in any way, shape, or form.
I don't believe this would come in under the co-conspirator exception. There are portions of it that would come in as a statement against penal interest, but it's going to need to be a whole lot more narrow than this entire conversation.
And Your Honor, I would ask that the court look at, if the court sees the case the way that I do, I'm not saying that it will, but Mosley versus the state, 307 Georgia 711 at Penn site 717, where at trial, Singleton testified that shortly after Brown and Mosley arrived at her residence, she had an emotional conversation with Brown in which Brown disclosed that Mosley shot Carter. Mosley contends that this statement did not further the conspiracy, but instead, quote, spilled the beans. However, the court found narratives of past events, and they were quoting Kemp at 303 Georgia, 385 at Penn site 395, stating narratives of past events are admissible under Rule 801 D2E if they serve some present purpose in the conspiracy. The court pointed out here that the context of Brown's statement is important, and then went on to say that it is clear that Brown relied extensively on Singleton for help throughout the week-long crime spree. The court noted that Brown used Singleton's telephone to set up additional crimes, including the one involving Knight, And Mosley and Brown continued their crimes while staying at Singleton's residence and hid the evidence in the residence while staying there. Brown's statement to Singleton, in which she identified Mosley as the trigger man, was made during an emotional conversation in which Brown asked Singleton for help. Thus, Brown's statement to Singleton was not simply a confession. Instead, it was made as part of Brown's ongoing relationship with Singleton and as part of Brown's continued need for assistance from Singleton, whether emotional or logistical, while she and Mosley continued to commit their crimes and attempted to evade arrest. Accordingly, given the liberal standard applied to this inquiry, it was not clearly erroneous for the trial court to conclude that Brown's statement that Mosley shot Carter was made in furtherance of the conspiracy. And we understand that the court may need more context than what it hears, but I just wanted the court to be aware of that particular case that we think might.
Okay, well, this doesn't seem to be that kind of a situation where he's saying pouring his heart out and needing support and logistical backup and anything like that. So I understand that that could be a co-conspirator statement in that kind of circumstance. I still find this to be that kind of a circumstance. So do you think you understand the portions of it that would be in against penal interest, or do we need to, you can take a look at it and then bring back a more narrowed one?
Yes.
Okay.
In my
Yes.
understanding, for statements against penal interest, my client's name would need to be redacted out of that.
Agreed.
It's against the penal interest of Mr. Garlington. It comes in against Mr. Garlington perhaps, but not against anybody else. I would not expect if it's a statement against Garlington's penal interest. And I would ask for a 105 instruction if this comes in.
Okay, well, I don't know if that would be appropriate considering that this is all also being considered in the context of the greater conspiracy. So if you can get me some law on that, I'd appreciate it.
And we'll just come back to the more narrowed down version.
Okay.
So we're going to skip down to, we're not saying, we're just going to come back to some of the other ones that I want to make sure that I have tightly tailored for the court.
Okay.
So we're going to skip down to page 235. And it's going to start at the beginning.
What's that? Yeah, how shit was what the movie? I wasn't get my session. I wasn't get my way. My mind ain't there yet. I'm really on the phone. Yeah, that's what I'm saying. No, I said, what the movie? Yeah, I'm just trying to wait. Yeah. I said, I ain't bro. I ain't made no money in about 2 days. I ain't. You too? For real, bro. Nigga, mine ain't done. I'm telling you, I didn't leave my truck. Yeah. Yeah. I ain't even got down. I still got that, bro. You know what I mean, bro? Yeah, that's right. Oh, what? I ain't right. Yeah, that's what I'm saying. You know what I meant. Oh, right here. I should be right here. Yeah. 20. And No, man. That time, I got low. Yeah. Got to, bro. Well, you got get with me, you know I'm at. Yeah. Okay, but, I got some hope. What's kind of, so like they don't work clear, you need to go on and show it, come to you and get up on me. Man. You say get out here? Man, say on footwork, but like there, let me come to you and get you and tell them to bring you. What you saying? I don't smack that shit now, though, shit. You did? Yeah. Hey, when, bro? What you mean? You want to tell you to get me up out of it?
This call is the call between Demekion Garlington and defendant Stillwell. And they are discussing their ability to sell narcotics, apprising one another of their narcotics. And defendant Stillwell said, you know where I am, I'm just waiting, as they are trying to get themselves resituated so that they can better distribute their narcotics.
Well, I will start out by, and I misspoke earlier. I think Your Honor realizes that Mr. Stillwell is charged with, well, he already pled to it. It's a 2013 possession with intent marijuana, which is one overt act as part of count one. Okay, after 2013, to my recollection, there's no other allegations of Mr. Stillwell selling drugs in furtherance of YSL. In addition, we have heard absolutely no evidence, and I don't anticipate hearing any evidence that there's any sort of profit sharing or anything else involved in drug distribution. We've heard about Durante BB selling drugs at a gas station. There was no indication that any of that money. Mr. Trontavious Stevens talked about his sale of drugs. He actually testified, and we asked him, and he was like, no, it was worth like $150. I'm not giving it to anyone. I was selling drugs. I acknowledge that it actually appears that they're talking about drugs and not selling drugs for the time being. But so that's not really furthering any conspiracy. But there's to say that just because they put in their indictment in count one an allegation of drug dealing furthering the YSL does not, in my estimation, open the door to any discussions of any individuals on trial selling drugs to pad their own individual pockets. There's nothing that supports the argument that this is some sort of vast conspiracy as alleged in the indictment. So to me, we're just end-arounding how to get in bad character evidence about Mr. Stillwell, about talking about drugs with Mr. Garlington. And so I don't believe it's part of any conspiracy. I don't believe it's in furtherance of any conspiracy. And I don't believe it's relevant, and it is prejudicial. And so 401, 403, and hearsay are my objections.
All right. I don't hear how any of what gets said in this particular conversation can be in furtherance of a conspiracy. So I'm going to exclude this.
Yes, Your Honor. And Judge, just so that I want to give a little bit more context to calls similar to this with the drugs.
Okay.
In this wiretap where there are, as they described accurately, about 60,000 pages of calls. There are more calls, 6,000, there are more calls on this wiretap discussing the sale, the distribution of narcotics than we have time to ever listen to during the course of this trial. So the idea that the calls between YSL members are isolated incidents that should not be deemed in furtherance of a conspiracy is belied by that very real fact that we could show if we sat here and just listened to all of the calls where they're talking about re-upping, selling, running out, who to get it from, where to go get it. So I just wanted to make certain we're not trying to revisit what the court's ruling just was, but I want to make certain.
Well, I don't hear anything in this call about where to get it from or re-upping or anything like that. I just hear them going, yeah, man, I'm not selling any, I'm not even. So
Yes, Your Honor.
there may be another one that might meet the requirements, but this one doesn't.
Yes, Your Honor.
All right.
All right. And so these calls as well, Your Honor, that are coming up are party opponent admissions because they are talking about right before they go to the gas station.
Okay, which ones are we talking about now?
The ones that are coming up next is on page 333.
Well, page number was unfortunately my cutoff of this, so. I know we don't want to be going by reference numbers, but
Oh, I'm sorry.
if you can give me a date and time, that's fine too.
Reference number is 326.
Okay.
And the date is March 14th.
All right, I got it.
2022.
9:56 and then 9:59 after that.
Yes.
All right. Is there any evidence that they have any reason to believe Mr. Drinks is going to be at this gas station?
Yes, I'll let Ms. Hilton. When you mean that before they get to the gas station, I think seeing him at the gas station is happenstance. When they see him at the gas station.
Okay.
So
I mean, I'm wondering, maybe there's something more going on here, but if they're just talking about meeting up.
No, Your Honor, I don't believe, we don't have any evidence to show that they knew prior to going to the gas station that he was at the gas station. I think that part was happenstance.
All right, well, I'll just have to listen to what the content of this call is to see whether this might be. Oh, I'm sorry, y'all are saying this was a party opponent, so I'm sorry, never mind, scratch what I said. Go ahead.
But we do think that they were on the prowl because Mr. Stillwell earlier that morning on March 14th had rented a car from Alamo at the airport and then went and got the car tinted.
Okay.
So we do think they were on the prowl, but not that they knew that Mr. Tracy was going to be at the airport.
All right, understood, thank you.
Hello? You know where it's at? He said, that glove? Yeah. Yeah, but like, when we get out there with the tub. I'm saying, we can get out the S literally right now. He just said that. I'm telling you, I promise you to get out the S right now. We stay right here. Yeah, no, bro. Tell Sam don't be mad, bro. We the bam, we the bam. He said, Well, no, I'm my mama on beat till we get out of here right now, man. All right.
So this is actually, we believe, not even co-conspirator here statements, but this is actually, we believe, evidence of defendant Stillwell's and Garlington's participation in the murder that eventually, the murder of Shamel Drinks. So,
Wait.
My client was not on that call, so if the state's just gonna say things like that, I need to know what they're talking about.
You're right, he is in the call, he's in the background, so when you hear, I believe the caller, I think maybe DeMarco Boyer saying, tell Shannon don't be mad, tell Shannon don't be mad, you hear Shannon make a response in the background. So I think him and Garland are in the car together, the other car is calling him saying, don't be mad, we're gonna meet you at the gas station, and Mr. Stillwell says something in the background.
Let me hear it again.
This spreadsheet says Garlington on the phone with Nichols, and now we're saying DeMarco Boyer's talking.
Nichols on the phone and they're using Boyer's phone. Because Nichols and Boyer and Miles Farley are in one car,
And
Shannon and Demikion Garland are in another car.
and how would they determine that that's Mr. Nichols?
Should we see that it's Nichols, Miles Farley, and then we are able to investigate that this is Boyer, investigator Reed is familiar with these individuals.
So we're saying that is Mr. Nichols on that call?
I don't know. Who are we saying is
Because
talking?
We believe it's Mr. Nichols. Now that's using Mr. Boyer's telephone.
there's a lot of we believe, and I have little faith in those assertions. In fact, I know those assertions to be incorrect. So
You said there's video from the gas station, right? And does the video from the gas station show who's in what car?
We know for sure that we see Mr. Jackson and the two cars around is an Audi and a Ford Fusion, a white Ford Fusion, a white Audi. We do know that Mr. Jackson gets out of the Audi.
It was Mr. Stillwell.
Mr. Stillwell, excuse me. And then we know that Mr. Nichols gets out the Ford Fusion and that Ford Fusion is actually his wife's car.
Okay, and do you know, are those the only two people that the video shows getting out or that you can see in any of the cars?
And one other person, Miles Farley, we know that he gets out of the car with Mr. Nichols.
Okay, so he's in the Fusion.
He's in the Fusion. We do not see Mr. Garlington. He does not get out the car at the gas station, nor do we see Mr. Boyer. He does not get out of the car at the gas station.
Okay, but your theory is that Garlington and Boyer are also in the Audi?
No, Garlington's in the Audi. We believe Boyer is in the Ford Fusion.
Okay, sorry. And you maintain that you can hear Mr. Stillwell at the back, responding in the call?
Yes, Your Honor, in the background, yes. It's faint, but you hear him.
Can I hear it again?
Yes, Your Honor.
Hello? You know where it's at? He said, that glove? Yeah. Yeah, but like, we'll get out there with the truck. I'm saying, we can get out the edge literally right now. He just said that. I'm telling you, I promise you, get out the edge right now. We stay right here. Yeah, no, bro. Tell Shannon don't be mad at bro. We can bound. We can bound. He said, yeah. Well, I'm my mama till on beat till we get out of here right now, man. All right.
Somebody says something like that.
well, what I hear is this. I hear Mr. Garlington speaking to someone, and them trying to explain to each other where they are. My understanding from what the state's saying, is this conversation occurs before, well, from the context of the call, before either car, or at least the car that Mr. Nichols is in, according to the state's theory, arrives at the gas station, which means this is before Shamal Drinks arrives at the gas station, which means there's nothing, according to the state's theory, nothing immediately criminal afoot. And they're just talking about getting up, and the person alleged to be in the car with Mr. Garlington is Mr. Stillwell. And, I can't really hear what was said in the background, but the context of what was repeated is Mr. Garlington saying, Mr. Stillwell's sick of waiting on you in a friendly way, and hurry up, and then saying, Shannon said, y'all are gonna bam, and y'all are gonna fight when he gets here because you're holding us up, and then them laughing about it. So I don't know what's criminal about any of that, or what's furthering any criminal conspiracy, especially since under the state's theory, Shamal Drinks hasn't even arrived at the gas
Yeah,
station.
no, I don't think there's anything further in any conspiracy here except a conspiracy to meet up at the gas station. So this would not be in under that exception for sure.
And I'd also point out, Judge, that it shows the coordination between the two sets of the called and the calling party, and the coordination. So even if you don't take what they're saying as true, the call itself is evidence of coordinated efforts and communication right leading up to the Shamel Drinks murder.
Okay,
So
but
it
y'all are
has
saying
nine
it was
purposes as well.
entirely just luck or bad luck for Mr. Drinks that they happened to find him here. So while there may have been a plan afoot to, when we see the enemy, we kill them, unless you've got evidence that this was, all right, we're getting together to go send out and start looking so that we can act on our plan, then this cannot come in under co-conspirator. It may come in under something else. But are you making that argument that this should come in?
No,
under-
that's the opposite of the one I was making. What I was saying is that it has a non-hearsay purpose, and that the non-hearsay purpose was that it shows the coordination and communication between the people that we've alleged committed the murder, even outside of the fact, even if you don't take as true anything that they're saying. So not even trying to take the truth of what they're saying, the fact that they are communicating with one another is one. And then the other was that we were saying was the statement of a party opponent, in that Mr. Stillwell was one of the people that was communicating.
Well, I mean, we can't hear what any of those communications are. So I don't hear anything coming in as a statement by Mr. Stillwell here.
If Your Honor could allow us one more comment on that.
No, I was just gonna say, Your Honor, we agree. We don't think it's a co-conspirator thing, but it is evidence of the events leading up to the murder of Shamel Drinks. And so we believe it can come in as we're not offering for the truth of the matter asserted that he was getting off the exit at the time that he says he's getting off the exit, but simply, like Ms. Love just said, to show they are the series of events that occur right before the murder, in communication to meet up at the gas station. You're gonna see that they meet up at the gas station, and the call that's coming up next is when DeMarco Boyer calls Demekion Garlington and tells him get on FaceTime. And we believe that is when the plan happens to kill Shamel Drinks. And that's the next
So
call.
does the video show the Audi's already there and then the Fusion pulls up?
Yes, but it doesn't, again, because of the video, we are not aware of DeMarco Boyer being in the car prior to seeing the video, nor do we see him afterwards. We just hear these phone calls between this individual.
All right, well, I'm not talking about the next call yet. I'm talking about this call and trying to figure out why we need this call at all.
Because I think it shows them coming from wherever they're coming together. We believe that they were either near each other or had planned to meet up prior to do whatever they're doing. And so it just shows a series of events, Your Honor. Just if we have to prove what happens before, during, and after the murder, it just shows before the murder they were in communication. Not like they randomly met up at the gas station together. They literally planned these two cars, at least, to meet up at the gas station. They meet. They unfortunately see Mr. Drinks, and then the plan becomes afoot. But it's not like the Audi and the Ford Fusion randomly meet at the gas station. They have plans to meet at the gas station. And
All right, well, if that's your purpose, I think you can narrow it down a little bit. We don't need to hear the whole conversation.
And Your Honor, I also said that they have a call log that establishes that, and they actually had Mr. Bernie, the cell phone analysis gentleman, plot this number in question that they're saying belongs to Mr. Boyer. They've plotted that, so they have a call log of who's calling who to show coordination, and they have the plot of where the phone was at times that it was used and who was calling who. So the coordination, they don't need the contents of the phone call to show coordination.
Yeah, but I would believe that the defense will argue, we don't know what they were meeting. We don't know what they're meeting up for, but now the jurors can
We
hear.
still don't know what they're meeting up for at this point in time.
But it's still just a series of events that lead up to the murder. These two cars and the individuals in these cars have some type of relationship.
If you want to use the little tiny part that's we're getting off the exit right now, that's fine. But we don't need all of it. I mean, it just.
And who's gonna identify the voice? Because it's not Mr. Nichols on that call.
Yeah, and we'll lay the foundation as to the call and where it comes from on the wire.
Well, if I'm admitting it as an admission by a party opponent, then it needs to be one of these people on trial right now. So if you can't establish that it's Mr. Nichols, that's problematic.
We will.
Well,
if I'm offering it to show that they were, not that they were getting off the gas at the gas, and that's the hearsay that we would need to. What we're saying is they were meeting up they were on their way to the gas station, not that we're getting off right now. That would be offered for the truth of the matter survey, which would be the hearsay.
Which would need an exception.
Which would need an exception. That's not what we're offering.
Okay, but if we have no idea who's on the call, then it's not relevant.
But we do know from the phone number that it's the Marco Boyer's phone. We know that he's talking to Mickey on.
You know what, let's just use what's already in for that. And by let's, I mean, that's probably the wrong word, but it appears that you all have what you need, and considering the other issues surrounding this one, I am gonna sustain the various objections. I'm not gonna admit this.
Thank you, Your Honor.
Thank you, Your Honor. And Judge, the next one that we have is omitted from the yellow sheet that the court is looking at.
Okay.
But it's going to be PDF page 351, March 14, 2022 at 10:50 p.m. It's not, but Your Honor, as I stated, it's not on the yellow sheet. It is in the Dropbox.
Okay, yeah, the yellow sheet was something that got sent later that was just to guide us, but.
What's the reference number?
It is the PDF page 351, reference number 345.
Hello. Hey, you went, right? Right here in the studio. Come on, you gotta kill them. Heavy outside, you rule war. For real? Yeah. I just seen Shakur post shit like that. Yeah. Yeah, I'm ready to come. Get out of the league. I'll let my story work. All right.
30, page 333. And reference number 326.
That's the one we just played.
No, yeah,
That's the one
no,
we just
yeah,
that
it is.
talked about getting off the exit.
335, 335, I'm sorry. 335, page 341.
Hey, what the hell pulled up? I'm my video, hurry up. Find my video.
It was the timing of this one, y'all can establish this is after drinks pulls up.
Yes.
Yeah.
Right.
Co-conspirator exception.
And so, just so we're clear though, that the state is asserting that because like the last one, there was some question about the involved parties. The state is still asserting that is Mr. Garlington and Mr. Boyer.
Yes, we believe that's Mr. Boyer telling Mr. Garcia get on FaceTime.
All right.
That is Boyer's phone number calling telling him to get on FaceTime. And this is right after Shamel drinks. When you look at the timestamp from the surveillance video to this call is after Mr. Drinks has pulled out of the gas station and they are pulling out behind him.
This sounds maybe noisy. Can you make it silent? That's all right. Okay. All right, what's the next one?
It's reference 350, page 357.
Jumping on the car, bro. I only gonna be getting dropped off and then got no motherfucking ride. Go back home to around next 6. Yeah. Which one you getting dropped off on? Nigga, ride with the nigga from groceries. Yeah. That's stupid fuck. Nigga, you didn't be on the good. We're right here down there. That one? Right past right see. I'm gonna meet up with y'all. I'm gonna get a fill up. I get a fill up for my right. Yeah. Alright. I said, alright, from this note, I said, I'm putting that now. You back to it. You say, I was gonna shut them child. Alright. That's what I'm saying. Kind of what you're doing. Alright, I'm gonna get full now. Alright.
This call is made.
1 in 7 people in America are living with food insecurity.
Mr. Boyer talking about having rolled back through the scene. The police were on the scene of the Shamel Drinks murder at
I didn't hear all that.
You didn't hear it on the call, or you didn't hear what Ms. Love was saying?
I didn't hear it on the call.
Yeah, I didn't hear.
Okay, this is them having, when they said, we just rolled back through the scene. I'll play that again. It was at least that's what this.
And this is supposed to take place at like 2 a.m.
Yes.
All right, let's hear it again. What pinpoint to me where in this conversation it was? second, is that supposed to be good? So, you know,
No, it's a minute-long call, so it's about midway, maybe.
go ahead.
Yo, I ran, all kinds of shit, man. I just jumped in the other car, bro. Now they gonna be getting dropped off and then got no motherfucking ride to go back home to. That don't make sense. Yeah, yeah. But what you getting dropped off for? Didn't ride with niggas with groceries. Yeah. That's stupid fuck. Maybe you need to be on a good or something. We're right here down here. That one? Right past trying to see.
Okay, so it's right there at 31 seconds, and the phone records, when he said right here, riding past the scene, their phone records put them at the scene at that time.
Okay, so right here, riding past the scene.
We don't believe that's
Trying
what
to
it,
see,
that's not.
riding past, trying to see at the scene.
Let me
Well,
hear that.
she keeps saying scene and no one says scene.
Let me hear it again.
And Judge, I want to make clear, like the court is doing, the court can judge whatever is being said, whatever it is they're riding past to see or the scene, their phone records place them at the scene of the Shamel Drinks murder at the time that the call was made.
But Your Honor, this is the problem. The state keeps asserting things as fact. He said through the scene, and now I'm just pushing back moderately, and now it's like, well, we don't really know what was said. And Your Honor needs to know what was said to be able to judge it. And if the state doesn't know, they shouldn't be asserting as fact. This person said riding past the scene, if they don't know that's what's said. And my belief, and I'm not going to assert it as fact, but what I'm telling the court is after listening to that numerous times on my own and several times in court now, I'm not hearing C. And I don't think anyone else is.
I don't know. Let me hear it again.
I'm gonna get what time they gonna get full up. Right there, fill up the pipe, right? Yeah.
Wait.
Alright, get down here. That one? Right past trying to see. Yeah.
Trying to
Stupid
see.
folks, you can be on a good or something. We're right here down here. That one? Right past trying to see. I'm gonna get what time they gonna get full up. That one? Right past trying to see. I'm gonna get right past trying to see. I'm gonna get what time they gonna get full up.
I mean, I don't know what he's saying, but they're talking about, I mean,
A little,
member is saying, I need a ride, right?
a little
It's
context.
saying- No, not right there, but before then. And they're saying, why don't you ride with the person you started out with? And they're trying to figure out where each other is, right?
He's asking, where are you? And he said, riding right here, riding past the scene, trying to see, either way you look at it, that the point at which he is saying that, yes, they are trying to apprise each other's location, and that person right there saying that he is riding past, his phone puts him at the place where Shamel Drinks was murdered at that moment.
I'm hearing, and I think everyone else is hearing over here, riding past around the city. Okay, around the city. And
maybe he is saying around the city, if they've got something that's good.
I don't believe, well, they just said,
I mean, it honestly doesn't matter whether he's saying riding around the city or riding past the scene, when what they're trying to do is communicate with each other about what's going down between them right after they have allegedly shot and killed somebody.
well, it's 4 hours after Mr. Drinks was shot. The context of all this meeting up is to go to the studio. That's the part that the state's not playing. They're all going to a music studio. And so I hear Mr. who they're saying is Mr. Boyer fussing at, it seems that fussing, someone should have gotten a ride with someone else, and he's fussing with that, and he's asking, where you at now? He says, riding around the city. There's nothing conspiratorial or anything else about that, but my bigger concern is we just have this situation where, like, if Mr. Garlington really said, I'm riding around past the scene, that would be some damning evidence. So we just shouldn't be throwing that out without knowing that's what's said.
All right, I'm not gonna let them hand the jury a transcript of this call that says that, because I don't think, I mean, it's up for debate what it says. I don't think, y'all don't agree, I don't agree. Who knows what it says? But I mean, it could very well be a part of a conspiracy, and they could be meeting up at the studio to figure out what it is that they're going to do next. That's not for me to determine. That is part of their theory. They can present this evidence in support of that theory. Whether the jury buys it or not will be up to the jury. But it is this I'm going to admit. Do we have lunches yet? Yes, okay, let's take a lunch break. We can all be back in an hour, right? Okay, let's be back at 1.
If you've been waiting to apply for disability benefits, don't. Hi, I'm Sarah, and I'm a lawyer at Atticus. Applying as soon as you're unable to work or struggling to work due to your
White demon with that lag, like you still compromise. Like you wanna play like that, like you 2 steps behind. Low on funds, bad credit. We got payment.
And I mentioned I listened to the jail call itself before that. And I'm just gonna add, in addition to everything that is set forth in the order on this from November 16th of 2023, not stated in the order, but I think relevant to the order, and it may just be because everybody already had it in their mind that it was true, but I just think it's important to note that the three speakers, Ms. Stanley, Mr. Holloman, and Mr. Minder, what their relation to each other was. And Ms. Stanley and Mr. Holloman, it appears, are brother and sister. I think we had already mentioned that Miss Stanley is Mr. Minder's mother, and that makes Mr. Holloman and Mr. Minder uncle and nephew. And then I just wanted to note an additional, there in paragraph 5 of that order, lists out several circumstantial guarantees of trustworthiness found by the predecessor judge. And I wanted to add, in addition to adding the familial relationship, that during the conversation between Mr. Minder and Mr. Holloman, Mr. Minder actually states to the effect that this wouldn't have happened if I hadn't been locked up. Essentially that, his uncle would have been under Mr. Minder's protection. And so I think that also provides another kind of indicia of their close relationship. All right, so I just wanted to go ahead and put that on the record as well.
May I respond briefly?
You may, but I'm not, I saw that you had already made the record, so I'm not really considering additional argument. Is that what you wanted
Well,
to?
I just want to respond to Your Honor. I guess the issues of sufficient or substantial circumstantial guarantees of trustworthiness in the order, Your Honor, indicated that it was apparently, those are the words in the order, apparently a close relationship evidenced by, it says, tone and tenor in that call. And additionally, it says it was unlikely there was an unlikelihood of and lack of a motive for fabrication on GH's part, or Gary Holloman, the deceased. That was in the order to those close contacts. And I just wanted to just make the record.
During the Rose to Go Labor Day sale, save big on this beautifully designed queen bedroom with dresser, mirror, and tufted headboard. It too.
Go too far about here, but in the argument and in the law, Your Honor, it says that the trustworthiness of the original declarant and whether the circumstantial guarantees of trustworthy are equivalent in significance to the specific hearsay exceptions, as the court is aware.
So I read the entirety of the argument that you made before the predecessor court.
Yes.
Okay.
I understand. Just want to put that on the record for the
All right.
consideration.
Thank you.
Thank you.
Okay, what's our next statement?
Judge, Mr. Atkins will be taking care of that. I'll go ahead and cue it up.
Okay.
Your Honor, we're gonna start with PDF page 360, which is 11 minutes after the call we last discussed, which was 3:57.
Oh, but that shit dead. One down. Yeah, one down. Fred, that's your opening now. Yeah. Take that. Yeah. I know you. That shit.
Your Honor, this call, which is at 2:12 a.m. on March 15th, 2022, so the early morning hours after Shamel Drinks was murdered, it's the state's theory that the utilization of FaceTime or other applications that are not classic phone calls are utilized either right before or right after or in the preceding moments after crimes. And so the state wanted to highlight that we had just played the call about rolling back through, however you hear the rolling back through the area that was the crime scene based on the cell phone records. This is 11 minutes after that, where this is Garlington and Boyer, who we've discussed, asking again to get on FaceTime. So that's why the state is playing this call and feels that it is a co-conspirator statement. We don't know what they are about to discuss, but that they're going to call on FaceTime at this specific period of time.
Okay. Is there objection? If there is objection, there's just uncertainty as soon as the voice that objection.
I think we have different objections. I'm gonna object. I don't see how this is furthering any conspiracy. I understand that the state wants to they have things in these calls that they feel is important and is relevant, but you still need the hook of the hearsay exception if these gentlemen are not testifying. So my objection is that it's not furthering any conspiracy.
Before anybody else makes one, just so I understand, so are you gonna have some, or have you already had some expert testimony that explains why a FaceTime call might be beneficial for utilizing in a criminal enterprise?
Old school Mike. Your Honor, two things. One, Demikian Garlington himself, in a call we have not reached, he explains, get on FaceTime because they can't record that SHIT. So he says that, I don't remember the exact call, but we will get to it eventually. And so for one, that's his own statement. Number two, I wasn't present when Detective Belknap first testified, and so I don't know if he addressed that, but it's my understanding that Detective Rito, when she is reached, is going to discuss, because it's intimately wrapped up into this murder of Shamel Drinks from the state's theory.
Okay.
And Detective Racy, who discussed the April 26th shooting of Mr. Dwayne Carter's tour bus, talked about how FaceTime doesn't show up in records. And so,
all right. Thank you. I'm gonna overrule that objection. Was there another one?
At the end, Your Honor, this is not, Mr. Williams is not on any wiretap, as you probably could tell. So I was going to ask for an instruction, especially if you let things in that's not in furtherance of a conspiracy, because then that should not touch Mr. Williams. So I was going to do it at the end, but when you asked for, are there any objections? Yes, I'm going to have an overall objection.
Okay, so I mean, this I am admitting as being in furtherance of the conspiracy. So with regard to any that I have let in not under that basis, but under a different evidentiary exception. If y'all wouldn't mind, I think maybe the only one that's occurred for so far is the one that I let in as a statement against penal interest. Okay. And Mr. Harvey had also asked for a limiting instruction as to that. Now, the issue that is still, I'm not sure 100% settled on this, is whether a limiting instruction is appropriate when the evidence is coming in to show, to prove some part of the RICO count, which everybody here is charged with. So that's what, you know, I'm not sure whether it's appropriate to give a limiting instruction in that circumstance.
I believe it would be, because if it's not furthering the conspiracy, and I'm not saying the jury will find Mr. Williams willfully and knowingly joined a conspiracy. I understand that, but the court must have made a finding that there was at least some evidence of a conspiracy. So then it becomes a statement. Right.
You make a good point there. Yes. So I guess yes, you're right. So if I have, and I did for that one, specifically said, I don't find any kind of furtherance of a conspiracy with regard to that one, then yeah, a limiting instruction I would think would be appropriate as to that. So if somebody doesn't mind keeping track of which of those need one, then if y'all would provide me also with a suggested limiting instruction, I would give that. I think that would be appropriate. Thank you.
And Judge, just for the purposes of the court's knowledge about the prima facie showing of a conspiracy overall, there was a finding prior to the court presiding of a conspiracy, that there has been evidence shown of a conspiracy. That finding was made particularly on the record as it relates to count one. Judge Granville said, he flat out said, I find that the state has presented evidence showing a conspiracy that tends to show a conspiracy.
Okay, sure. But we're talking here about a statement that's not made in furtherance of a conspiracy. Would that statement come in to show as evidence to prove RICO?
We believe that it would. The purpose of the co-conspirator statement is to provide an exception to the hearsay rule.
Right.
And the fact that the court admitted it under another exception to the hearsay rule doesn't make it applicable only to proof of against the declarant.
Okay, well, I'd love some law. I guess maybe that's still not settled. So I'd love some law from whomever wants to provide me some on that. I mean, that's very nuanced. So we want to get it correct legally. All right.
Your Honor,
Mm-hmm.
if I may.
Sure.
With the call we just discussed, number 360, case number,
Yeah.
what was the court's ruling?
That is in as a co-conspirator statement.
So specifically for that one, as made, like the discussion we just had about.
Yeah, the only one that I have so far, there are two I haven't let in and one I let in under an exception that wasn't co-conspirator.
Yes, Your Honor.
So for the rest of them, they've all been under the co-conspirator exception.
And Your Honor, for your notes, I believe that was at page 152.
Yes, mm-hmm. That's right.
Thank you, Your Honor. The next call we're going to be turning to, Your Honor, is going to be 4/23. And just to give the court a little bit of backstory, in addition to what Deputy Hilton discussed this morning, is this call is on March 16th, 2022 at 12:22 a.m. This is when at 2830 Waters Road, APD police officers arrived approximately around 12:08 a.m. after a lot of gunshots, which resulted in 11 defects in the front of that home, which ultimately inside of that home was Defendant Stillwell, Demekion Garlington, whose wiretap we have, Miles Farley, who is not in the current trial, but is charged with the murder of Chanel Drinks, as well as other YSL associates. And the significance is the shell casings from the murder of Mr. Ford and Mr. McMiller were connected with the Waters Road. And so this retaliatory back and forth, that backstory is significant with these calls we're about to play.
Okay.
So, Your Honor, with that said, I'm going to play PDF page 423. And for this one, we're going to play the entire call.
Like my little bit. Dude, how many did you at? Where did you at? Hey, you like my little bed cut? Oh no, wait. They in the front, and they got goddamn get to their back. They can't come in the house. Yeah, they were right. So that's what I open the door.
And so, Your Honor, them whispering, this is Mr. Boyer, who Garlington is speaking with, his phone number. So officers, when they arrive, they ring the doorbell camera. There's a brief exchange from someone inside, and then they don't respond anymore. And ultimately, Demekion Garlington was in a crawl space. It was raining that night. And so the significance of this is they're speaking amongst each other because they don't initially know who's at the door. Police respond because of all the shots that were into the home. And so it shows their coordination. And although the phone number itself for 423 is Mr. Boyer's, one of my co-counsels had stated we believe it's Defendant Stillwell on the call. But the significance of them speaking while it's 20 minutes after APD arrives to the house. And it takes some time for them to fully come out of the home. So it's in furtherance of the conspiracy because they're coordinating with one another about where are you? He says, I'm in the woods. And then I believe Mr. Garlington is underneath the house when he's making this call in the crawl space.
So the context of this call is it's directly after, to my understanding, individuals shot at 2830 Waters Road. That would not be a crime committed by our clients. I don't know what could. I think the context of the call makes it clear that they're trying to avoid interactions with the police. I mean, I'm not going to argue that that's not the context, but I don't know if that's part of a criminal conspiracy. I mean, they were just victimized and they're trying not to talk to the police about it. I don't know if communications on a phone about that would be in furtherance of the conspiracy because there's no underlying criminal act, as far as I know, that is being furthered.
Your Honor, the conspiracy itself, coordinating with one another in the wake of an act that has been committed in the wake of criminal activity at that house. We believe that the other calls will show that there are guns in the attic that they want to keep concealed from the police. They want to keep themselves secreted and separate from that location. It's one of their trap houses. and them coordinating with one another to evade detection by the police does further the interests of the gang by keeping themselves from being detected and found out and connected to that house by the police. So calling to find out where each other is, because the police did descend upon this house where hundreds of shell casings were found in the yard. And it was one of those central locations that was involved in the wake of the shooting of Mr. Ford, Mr. McMiller, and Mr. Drinks. We believe that this communication does further the conspiracy of the YSL enterprise and the criminal street gang, and its enduring, detection from the police for their criminal activities by apprising each other of where they are in relation to the hot spot or the hot zone.
Okay, and let me ask you so that I am sure what my understanding of it is. Mr. Atkins, you had said shell casings from this scene are connected to the Drinks murder. So this wasn't just like a shoot up, this was a shoot back and forth.
So Your Honor, the shell casings from Waters Road connected with the murder on March 11th of Mr. McMiller and Mr. Ford, who were.
Okay, I misunderstood you.
Yes, Your Honor.
Okay.
So
All right,
it's the state's belief that the rival gang was responsible for both.
no,
of
I
them.
understand, I just had written down the wrong set of murders.
And Your Honor, I left out one, I think, relevant fact. The police actually did come in contact with these individuals eventually,
Mm-hmm.
and they released them without charging them with anything.
Is that before, or, I mean, did they search the house at that
Yes.
point?
Yeah, well, they see a gentleman in the house laying down, and then they trying to speak accurately about how this happened. They went into the house. That's right. They went in the house upon seeing someone on the ground and detained all the individuals and then let them go without filing any charges.
They didn't search the house that day. They went in and detained, and Mr. Stillwell was later found to have been wearing at the house the same clothes.
Okay.
But no, they didn't search the house at that time. They didn't have a search warrant for it.
I never said anything about them searching the house or not searching the
But
house.
that's what I asked.
They went in the house and detained people and then released them without charging them because
And
it was
without searching that.
and without searching the house. They later searched the house.
Okay.
And I don't believe anyone is charged, and correct me if I'm wrong, but I don't believe anyone in this indictment is charged with anything that was found in the house.
They didn't find anything because they took it out before the police searched the house.
So
They can't hear what you're saying. Pull the mic. Oh, great, we've got a second mic. Good deal.
They found some stuff, but we believe that the things that they referenced in the calls were removed from the house. There was a number of things that were in the house that we know were in the house prior to them searching the house that were not in the house when they searched the house.
Well, based on, and we're gonna hear that soon enough.
Yes.
Based on what's about to come up, I'm gonna admit that under the co-conspirator exception, since there's apparently some evidence that they were concerned about some criminal activity or contraband or something in the house.
Yes, and I think that the next call might share
All
more
right.
light on it.
So Your Honor, the next call we're turning to is 472. So the call we just played was at 12:22 a.m. This is at 4:33 a.m. again on March 16th.
You good, man?
Hello?
You good?
Yeah, who is it?
Hey, green, man.
I ain't even say, I ain't saved no number.
Yeah. Oh, yeah. So,
Where the hell you at? You gone?
Yeah, I'm about to drop miles off.
7 miles, boy, it's all love, boy. I couldn't wait, boy. I gotta go home.
Oh, yeah. Yeah, he just ran in the store real quick.
Yeah, so it was all love, yeah. I ain't waiting, but I gotta go, boy. That shit just shook the fuck out of me.
Man, man, when I say this, when I say yeah,
Man, what? Man, that was just, man, boy, listen, boy, I just said to myself, boy, man, let me out of the car, boy, man, go in, boy, and I ain't coming back outside, boy. I don't care if I have no run or nothing, boy, them motherfuckers ain't moving.
hey, what? I was getting the same shit, what? Somebody really think I'm like, man.
What's so crazy, bro? I was just being cheap. I keep being cheap. My don't keep saying, let me get wrong like him. I'm not gonna pay no wrong. Man, listen, boy, I just said, damn, boy. They just send a nigga right street with their money like that. My nigga gonna spend this shit on the room, man.
Man, what? I'm
Fuck
so hey, that's on TV. I'm in like, I got my last 2,000. I got to lawyer in. I'm like, man. I'm gonna be like, damn.
But you wouldn't believe, boy. All the sticks and the guns was in the gray car.
For real?
Man, guns, boy, and the sticks and shit in the attic.
Ooh, shit, boy, that was dog, boy.
Yeah, what?
Your Honor, I'll continue playing, but when they're saying that the sticks are up in the attic, it's the state's theory that they're talking about the Waters Road house. When we were just discussing what's inside of the home and not inside the home, it's the states that line about the sticks up in the attic. Sticks is short term for AK-47s or longer handguns. I mean, rifles, that they're talking about the guns in the attic of the Waters Road home that all these police swarmed after the gunshots. I'm going to continue playing. And also to orient the court, Your Honor, this.
Okay. 1 in 7. Communities all across the U.S.
Hey, you know what I mean?
Yeah, man, you know how far I go.
Yeah, blow it up.
She what?
She blowed it up, boy.
Hey, man, she blew my shit up.
Man, shut it up, hey, man.
All right.
Yeah, man.
Yeah.
Hey, you walk in, these girls think, I'm like, I know for a fact.
Man, what? You know who she was coming to then?
You say all this same shit, though. You like, you like, who out there? I'm like, I don't know. I'm telling you, my first time here. She like,
Yeah.
So, yeah.
Man, listen, bro. I'm thinking, you know what I kept saying? I said, well, I know D and Miles, I'm smart. I know they some of them folks got her and took her to the front. I said, I know they hit that back cut.
I'm trying to find out. Back cut. That's why I called you.
Man, you talking about, wow, I would have made one straight through the motherfucking bush back up. Wow, I'm telling you, I would have striking back, huh?
Get what? We only got caught. We done that once they said, no, he thinks somebody in the house, yeah, bro.
But they tell me, like, so you telling me nobody in the house? I'm like, man, I ain't listen, man. I just pulled up. I said, I sat for 3 minutes. Top. The motherfucker go popping. So shit. Oh, God. Well, I sat outside 3 minutes. Popping. That motherfucker went to popping. So shit. I went to goddamn jugging and running. That's my soul. Why you That's my so why you ain't got down? I thought it comes from also. It's my so why you ain't got down come out when we said 11 police? I'm like, shit, I don't trust 11 police. I'm thinking these folks. I'm thinking these folks trying to get her to come out. So I'm shit, I stayed in. Yeah. Oh God. They're like, yeah. I'm like, yeah. I'm like, look, bro, y'all question me like I'm a suspect. I'm a victim. They're like, yeah, you right. They're like, but let's do what we gotta do. We're gonna get back with you. If everybody come out clean, then we'll let y'all go. Like, stay lit. I'm in the car sleep. I can't wait. Well, they tell me that I kick back. Don't get down. Go back. Yeah. Oh, God. You know that? They can't get to see the other stick. Yeah, man. But you wouldn't believe, but I'm here over like, well, I know they can't come in here. We good, Brad. I'm telling Brad, like, we good, but they fly private. I was up on the house, man. You don't see how dirty I am?
Hey, move. Damn. I go out the back door. So I go out the back door, right? So I'm gonna go toward the corner. I hop in the car and sit in the car all the time. That's where they get to. And I go to the other side, then try to hop the fence. They like, yeah.
I'll tell you what you're gonna do. Go get that cut, boy.
I know it. I remember what it was. They said, you know.
Man, listen, man, you could have made your cut. You're like in from the hood, but you know how this shit go. I would have went back there and made me a cut, but I would have been tricking through the motherfucker. Don't I got that shoes so dirty, my pants dirty, and my shoes dirty.
They said, so this is about that, man. I said, man, I don't know.
Man, listen, man, they asked me, do I know Batman? I said, I don't know no motherfucking Batman. Who is that?
Yeah.
I said, man, I'm not even from over here, bro. I'm from Tumbleweed area, bro.
Yeah.
So what you doing over here? Man, I can't see a friend, man. I'm trying to talk about this game, man.
What you talking about? Damn, man. That whole blowing me up. That whole thing, nigga, Sheen, all type of shit. That nigga was so cool, though. He got damn cars back. I need to put a lock on the phone and take my, like, how my messages pop out.
This shit crazy, boy. I'm finna go in, but I'm finna get out the driver's seat, let her drive, tell her drive slow as possible. Cause I got down, my stupid ass went in the car, got my stick out the car, and my infant out the car. Watch her right there, and got in the car, pull it up. They're really why I ain't want to wait on mine. All right. I'm gonna take you now. Hey, I was blowing her air. She called us up. So, how she get? So, how she get? No.
I don't know. You know, Kira got my Instagram on her phone. Everybody's DM like, is you okay? So, goddamn. Yeah, blowing up. So, when Kira's already on the phone, I get Kira and her number. So, yeah, folks. I don't know on the phone. Damn, but I say, I'm like, yo, bro.
Bro, listen, bro, I kept saying to myself, I don't know what the fuck, I'm on drill time though, so I'm really like, I ain't going nowhere. But I'm telling myself, pull out, nigga, pull out. Man, listen, you said let go, Miles said let go, Brad said let go, but I'm on drill time, so I'm just like, man, fuck that, boy.
Yeah.
I'm so mad. They tell me like they served, he was just telling me like, he was like, he's somebody called D or your girl or it's that whole Elmo, cause they serve Elmo. I was like, man, Elmo fuck them folks.
Yeah. Ain't nobody calling me, nobody on the freeway when I got off the night.
Man, listen, man, don't nobody know my whole come out in a room, man. Fresh room, a new room. Them motherfuckers just got in the room. And my whole coming from goddamn, I always got down out here, so come on, man, stop playing.
Yeah. Don't even know what I'm in. I don't know about myself, yo.
So nobody know what I'm in. That's what I'm telling. Like, these folks ain't knowing these cars. That's what I'm telling him. Like, bro, these folks ain't knowing none of these cars, bro. All these cars, new goddamn cars, new ain't played.
Yeah. Damn.
They're crazy, bro. Don't nobody know. Them folk don't be knowing where that spot at, man.
Yeah.
It's like they had Trump out, bro.
But on God, I know what I would do. On TV, what I would do.
So I had, yeah, hey, I ain't gonna lie, but I know you had my son here, but I'm happy as hell, but I just was saying to myself, you know what I just was saying to myself? I just was saying to myself, boy, man, all these niggas might get out of man, D, boy. Oh, man, God. Go out to him, boy. Yeah.
That's the end of that call, Your Honor. The state feels this really has two methods of admissibility. The state feels that Garlington and defendant Stillwell speaking about, for one, when they say sticks and FNs, those are firearms. They're mentioning about a female they know, and they say that she's dating or sleeping with the ops. They're also mentioning how APD, this is 2022, was the APD gang units was following the YSL, YFN, IF gang, back and forth. And so they kind of, in APD gang unit, when they were talking about, they're like, I don't know McName. They're laughing. They're kind of saying, I just got to the house. APD is thinking like before the investigation is complete, because the shooting just happened, that it was probably YFN who just shot up this Waters Road, which is a known YSL spot, because they believe that they murdered friends 5 days ago. And so with that said, all of their conversation, they're talking about getting away. You should have run this way through the woods. And when he says, I'm on drill time, because they were just shot at by the state's theory of rivals, if you're on drill time, you're trying to go shoot somebody or murder somebody in retaliation. And so that's why he says, I was so mad. I was on drill time, but the police came because they were just shot at, so they all hid under that at that house. With all that said, you have statement of party opponent against defendant Stillwell, but the state feels that they're keeping abreast of the conspiracy, talking about how they evaded police detection, at least for some time. When they're talking about, I think they used the term Miss D, they're talking about Detective DiVerito, who also used to be a probation officer and is very familiar with the individuals at that home. And so what happened in terms of the search warrant, Your Honor, is the search warrant was executed March 17th. This was March 16th. But pending any questions from the court, that's why the state feels this is admissible.
So I'm going off of my understanding of the events, and I'm sure Mr. Atkins will correct me if he disagrees. I don't believe what was said earlier by another person on the state side was completely accurate. The police entered the house. They secured the location. They searched the house. I believe, and Mr. Atkins, correct me if I'm wrong, but my recollection is they did find firearms and they found ammunition. The reason I bring that up is because none of the firearms located at the house had anything to do with any crime scenes on this case. So when we're, the state's saying that that's my client, it's clear the context. There's statements, I think retrospective statements about guns. My client, to admit against my client, I concede would not have to be a statement by a co-conspirator. I believe that my argument regarding Mr. Stillwell's statements are 403. He's talking about guns. He's talking about a lot of guns. All that is bad character, bad. It's prejudicial to us. And I don't believe that any of these firearms that are found in the house, I know none of the firearms that are found in the house have anything to do with any of the charged crimes in this indictment. So that's my argument on behalf of Mr. Stillwell, who doesn't really have a co-conspirator argument.
I think it's more an admission of a party opponent, but it is all retrospective, I believe. And therefore, insofar as it may be a co-conspirator's statement, it is akin to the classic spilling the beans. Man, this is what we did. They came in there. I was running out to the woods. That's all saying what happened. And what happened is the classic spilling the beans. So I don't believe that it would be admissible as a 801D2E statement, would be my position. Be admissible against others, but not as to the conspiracy.
Potentially admissible against others. That's what Your Honor, the classic argument always in furtherance of the conspiracy is always, defense counsel who's trying to keep out a statement is going to orient to spill the beans, and the state's going to argue its furtherance. That is the crux of the matter always. The state, and this is in the state's filed response to Mr. Shard's motion for reconsideration on what Demekion Garlington told Kenneth Copeland when we filed that a couple weeks ago. But the seminal case is Kent v. State, which is 303 Georgia. I'm using my motions quick-hand to find the site. The 303 Georgia 385, which is 2018. Another important case is Chambers v. State, which is 304 Georgia 88. Oh, my apologies, Madam Court Reporter. Yes, Chavers v. State, 304 Georgia 887, which is a 2019 case that also cites Kent. And a key part here, when you have, take aside the Rico count one, you have a criminal street gang, the statements that keep other co-conspirators of the larger criminal street gang, not necessarily the individual murder or crime, keeping them abreast of even past activities, that, and also statements that foster cohesion, because when you listen to this call, right after they've been shot at, right after the police that they were not clearly trying to evade were there, they are speaking about all of those events in kind of a cohesive unit, right? They shot at us. The police were trying to get us, and they're talking about what happened. So the case law within Kent, Chambers, all of that is why in gang cases, the criminal street gang, and also the count one conspiracy, which kind of become part and parcel of the same in this case, because it's YSL Enterprise, as the state alleged. Those statements, even of past activities, do serve a purpose because they keep cohesiveness. It keeps an us versus a them, and keeping each other abreast of the criminal enterprise's activities, whether the person speaking or receiving that information individually participated in it. The criminal street gang's activities is something that the case law allows as 801D2, as in furtherance. So I just wanted to highlight that for the court, because the state's argument is going to all, when appropriate in this circumstance, the state feels it is, it's going to be in the under the prognosy, so to speak, of Kemp, Chafers, and I believe Hassan v. State, which is a March 19, 2024 Supreme Court of Georgia, also discusses this, but I wanted to confirm that. But that's a much more recent decision for cited to the court. But that's the state's response, Your Honor.
Okay, but can I please respond to that? We're talking about, the state starts by saying, oh, the defense always says it's not, it's retrospective. Well, the state always says, they throw out these buzzwords, cohesiveness, kept them apprised of the events. So the buzzwords from the state are the same they're accusing the defense of using, but it's the same buzzwords, it's the same thing every single time. And there are just as many cases out there that say retrospective prior conversations are not part of the co-conspirators exception to the hearsay rule. Stafford versus the state, 312 Georgia 811. State versus Lane, 308 Georgia 10. State versus Wilkins, 302 Georgia 156. There are cases after cases after cases that specifically say a retrospective statement that merely recounts what happened. That's the whole tenor of this conversation is not in furtherance of the conspiracy. So, you know, buzzwords go both ways, baby. And I'm just as tired of hearing the cohesiveness and keeping people apprised. So, you know, there are two ways that this goes.
Thank you, counsel. I'm going to admit this as a statement by a party opponent as to Stillwell and admit it additionally under the co-conspirator exception.
Your Honor, the next call we're going to go to is 5/12, which is, again, March 16th, but it's much later in the day. The last call was at 4:33 a.m. This call is at 6:49 p.m. Mr. Harvey, it's page 512.
Okay, I got it. I'm sorry. Right.
Yeah. Ain't told me you had it. You do. You say you had a few different flavors, right? Flavors. Oh, okay. The same though? Yep. Okay. When I got now, it too much going on yesterday. Man, it's crazy here, man. Two ahead, they got 3-4 now, man. For real? Sweat. How old is you? Yeah, now you know they shut up Big Nick spot. I was in there. You think? Oh, they shut up Big Nick spot, bro. Yeah, man. So we got down. You think they gonna come back? You think they gonna come back? They through? 12 pulled up. Man, yeah, I'm gonna come through the window. You know how this in the living room, it's crazy, but nobody can hit. And you know when one big, when one damn one y'all don't get hit, bro. Yeah, for sure. Man, when they look perfect today, in kindergarten, about 2 nights ago. Boy, that's wow. I don't even think know that. Boy, he gonna. You know, the play had locked up. That's the only reason seen his ass. Why I didn't even know that? That's the only reason you ain't seen him, huh? Yeah, this shit was last night. Like you talk to him on the phone, you know what I'm saying? It's like shit got set up, you know what I'm saying? Yeah. Damn, he gonna. That nigga, that crazy, bro. Yeah, man. That crazy, bro. Your ass be goddamn be smooth, bro. Man, yeah, bro. But it's too much going on, like this shit. Too much going on, man. Nigga, bro. My hell, y'all ain't got no trouble on these niggas, bro. Man, nigga kind, bro. That's wild, bro. That's wild. I'm on the way to the spot. I check out down, you know, then pop out, pull up on. Alright.
So, Your Honor, they were Big Nick spot that they reference is what they refer to the Waters Road address as. And when they're discussing about those other people shot us. And the state's theory is they're talking about the rival gang. And they're, stating that it's crazy that no one got hit because there was a significant amount of shell casings at Waters Road. And then he states, one of their partners died a few nights ago, which the state believes they're talking about Chanel drinks because this happens after that. And so the state feels that this conversation discussing all of those things, even if it's kind of thinly veiled, is again keeping abreast of the gangs, the criminal street gangs' activities, and sheds light on how they are viewing what happened at Waters Road from their own mouth and mind.
All right, can I hear it again? And it really would help if y'all would give me your argument first, so I can know what to be listening for.
If you've ever considered the government is ending an old policy that prevented thousands from getting disability benefits. Since the 70s, the SSA has used an old list to determine what types of jobs were out there. The SSA would reference this list to determine if there is work that you could do, even if you had severe limitations. Last year, nearly 40% of denied applicants were denied for this reason alone. Now, they're changing the jobs list, and that'll change your odds of winning benefits. And you can improve your odds even further by working with Atticus. We help you through every step of the disability process and win benefits for over 80% of our clients. Call us today.
They told me heavy. I got it, bro. I got it. I got a few different flavors. You say you got a few different flavors, right? Flavors. Oh, okay. The same though? Yep. Okay. When I got down, if the two ain't going on yesterday, man, it's crazy there, man. Two ahead, they got 3-4 now, man. For real? Sweat. Yeah. Yeah, now you know they shut up Big Nick spot. I was in there. You think? Oh, they shut up Big Nick spot, bro. Yeah, man. So we got down. You think they gonna come back? You think they gonna come back? They through? 12 pulled up. Yeah, I'm gonna come through the window. You know how this in the living room, it's crazy, but ain't nobody can eat. And you know when one bid, when one day one of y'all gonna get yeah, for sure. Yeah, man. Yeah, what they look like today? About 2 nights ago. Boy, that's wow. I don't even think they'll know that. Boy, you know, the play had locked up. That's the only reason you seen his ass. Why I ain't even know that? Hey, that's the only reason you ain't seen him, huh? Yeah, this shit was last night. Like you talk to him on the phone, I'm saying it's like shit got set up. I'm saying, yeah. Damn, he gonna do that. I ain't gonna lie, that nigga, that's crazy, bro. Yeah, man. That's crazy, bro. Your ass you got there be smooth, bro. Man, yeah, bro. But it's too much going on, like this shit. Too much going on, bro. Nigga, bro. Hey, y'all ain't got no trouble on these niggas, bro. Man, nigga kind, bro. That's wild, bro. That's wild. I'm on the way to the spot, but you got down, you know, let me pop out, bro. Pull up on. Alright.
Any further argument on this one?
I have some, Your Honor. We don't know who Mr. Garlington's talking to. Mr. Stillwell is not a part of this call, so this would have to be a statement in furtherance of a conspiracy. There's no apparent conspiracy, criminal conspiracy that's being discussed. It's a retrospective statement about them being shot or them being Garlington and I don't think he names anyone else that was there, but Garlington is telling this other unknown individual that people shot at me at Big Nick's spot last night. That is a retrospective statement that falls under the line of cases that Ms. Harvey just cited, and there's also, of course, 11th Circuit cases that talk about spilling the beans as well. So I don't believe that there's any apparent conspiracy that is being discussed here. They're victims, and also anything that's said that's a retrospective statement is not in furtherance of the conspiracy.
Okay, well, I don't hear it as entirely retrospective. They're talking about whether they should be thinking people are coming back, whether they've got the drop on people. It sounds like that's still an ongoing conspiracy, so I'm gonna permit it under that exception.
Your Honor, if I could be heard just briefly on the issue.
Yes.
I did, sorry.
Like,
I know, where's this
literally,
coming from?
yes.
Judge, I did hear in the audio recording a name, Quay,
Yeah.
that was heard, and under 403, in an effort to not be misleading or confusing the jury as to, there are a number of people on the indictment that have names that are similar in nature, so we don't know what Quay or that they're referring to. I would just ask for the court to provide at least somewhat of a 105 instruction that deals with or ferrets out who they are actually referring to, because I don't believe, I know that they're not referring to Mr. Marquavius Hewitt.
Okay, and
So I would like to.
is the AKA, I don't know how to say it, I wasn't here for the beginning of this trial. Is that also Quay or is that Qua?
Well, from what I.
Or no, that's Mr. Nichols. Qua. Are there any Quays that are AKAs to any of the co-conspirators named on the indictment?
No, but there are plenty of Quays as opposed to Quas that are mentioned in these wiretaps, none of whom are identified. This particular phone conversation has a Quay is locked up.
Yeah.
And that, well, I didn't want to bring this up.
Any idea who the Quay they are referencing in or belief as to who that is?
Your Honor, as I do not know who exactly they are speaking about. I can work on finding out, but I do not know.
Any idea whether it's a member of this alleged gang or another alleged gang?
I do believe they're speaking about, well, I want to get clarity from exactly who they're speaking about before I speculate. So I will find that out, Your Honor. And the state's position as well is if the state, there is any number of things in a trial that can come up that the state is not going to be, other than this wiretap played before the jury, the state is not going to be making any wild reference about who that, like this specific second clip where they say that is not going to be a huge theme in the state's case. So I don't feel that a limiting instruction is necessary, but I still will determine, at least within the gang experts, maybe who they believe and who the state's theory believes they're talking about.
And the reason
Somebody can probably tell me the nickname or street name or whatever that Mr. Huey is alleged to go by. How is that pronounced?
in the indictment.
Right, that's what I'm talking about.
Initially, by the predecessor judge, he used Qua, and then there was a correction or amendment to that reading, and he referenced Quay. So Mr. Huey has been referenced in the indictment and has come out during this trial.
In front of the jury?
In front of the jury. Do you know Quay?
Okay.
So that's why it's important for our team to make sure that there's no misleading or confusion under 403 as it relates to who they're talking to in this particular.
I mean, it sounded to me from the conversation that they were not talking about anybody that they were a compatriot of, but possibly somebody that might have been the opposition. But yeah, we can circle back on that.
Thank you, Judge.
Your Honor, the next call we'll be going to is 6:35. This is on March 17th at 4:10 p.m.
Give me just a second.
Yes, Your Honor. Oh, I might have skipped one, Your Honor. I actually believe the next one's 5:23.
That's what I was about to ask.
Thank you, Mr. Sharp. Which is at 9, so it's roughly 3 hours after the call we just discussed. And
Okay.
yes, Your Honor.
So 513. What's the page number?
It is page number 523, reference number 513.
Okay. All right.
And Your Honor, the state's theory of what this call discusses is, for one, there's a mention of they flipped a car under the bridge by the Ville. The Ville, the state believes, is Mechanicsville. Chanel Drinks was murdered near a bridge in a vehicle. And so they're also discussing the funeral of the March 11th murder of Mr. Ford and Mr. McMillan.
Do we know who the other person is?
So the call, the phone number, which ends in 0484 for this call, I have associated with a Mr. Wright, who is a 30 Deep member, according to AP Game Detectives, with a nickname of WOT. So, Your Honor, we're going to play that call now.
What's up, man? I ain't seen you, man. Yeah, but I ain't talked to the nigga ass. Yeah, man. Oh, yeah, I didn't talk to Freddie. He asked me like, yeah, he called me after that little shit on there. I called. He said, I'm straight. What, man? Oh, yeah, I mean, like, I called the detail on there trying to check up on him, man. Yeah, folks hit. My folks shot the spot, man. So, what, he did something free. Man, like, well, you know, I wouldn't even come back. Man, yeah. Like that now, pull up. But yeah, I was in there. Then, for like 6 feet. Talking, man, yeah, them going out, man. Damn, that's a fool. I thought they already went over there and shot one upside. Yeah, man, that's every day. They double back. Oh, it's like, yeah. Oh, I know about what it is, right? Oh, no, I heard it a couple days ago, somebody, they said they went over there. Oh. That's why they know. Yeah, man. They just went over there last night. Yeah, man, we down. I'm like, hey, man, fuck, I'm gonna need to come over here, man. Yeah, you talking about, yeah, I ain't even know that about this. Yeah, bro. We like, you know, we think, we like, they gonna come back through. Man, we think they gonna come back through, so we can hit that motherfucker up, man. 12 put up. Hey, right? And how do you know what to do? We hit them for like, cause we got our right, bro. For like, we gonna have to come in. We gonna have to come in and goddamn make sure I know how to do it. Man, hit the back door like that, but I'm gonna roll in, man. I get shit in here, man. Hey, you come back, y'all have to come in. Yeah, no, we just talk to the other outside. Yeah, we go in, make sure I know like, man, if you don't know under the house. Goddamn, man, about 4 of us in the house, they keep you, man. If you don't go out, I'm like, man, fucked up, man. You took out right? I hit the back door. It was on both sides.
was just like, I seen him on one side, I was just in the car, in the yard.
Yeah.
I seen them looking at the car go back to the other way. They know they was over there. I was like, hey, come here. I'm like, hey, man, they heard some gunshot. Yeah,
Yes, you
man,
see.
they heard a gunshot, man.
Okay.
Yeah, that's where you come from, like, ooh, I'm dry here. It pouring out like. Them folks like, man, you ain't waiting around with that. Tell me, man. I was in the woods. I don't know how I ain't wait. I was in the woods. But I ain't no sound.
Man, what?
Yeah, shit, I went in out, man.
Hell no, I ain't got nothing to do with
They
that.
still in another shit. I like, man. And we say,
Oh, they ain't certain. They just look around.
Make sure I'm like that.
Yeah, so when nobody know they went in?
Yeah, they found. No. Goddamn, look away. Yeah.
Okay.
Yeah. I'm like, yo.
But he hit out?
Yeah, I'm finna pop out for Coke on her. Coke, so they got a little video shoot.
Oh, they got a video shoot.
Yeah. I ain't really been outside, bro. You ain't got nobody who been trying to save no pill. But nigga, bro.
Yeah, I think I'm up to get some beer tomorrow.
One guy they told me get 120 tomorrow. Shit, that 1800. I told him get me all. Then I gotta get some weed. But I ain't make no money in 5 days, bro.
Yeah, they got me, so yeah.
But now there ain't too much going on.
Too much going on, yeah, they gotta see what's going on. They some niggas get up on the bridge in the video.
Yeah, I heard.
Yeah.
I heard. What the hell you at?
I'm right here in the video. I'm right here in the stove.
You say you at stuff?
Yeah, there's a little 2 bucks that I had at the bottom.
Yeah. Where the hell you been at, man?
Shit, I've been around the way.
Yeah.
Yeah.
I don't really be popping out at nighttime, though.
Nighttime. Everything been going on in the day, though.
Yeah.
They been dry here, motherfucker.
Well, I know it, boy. Oh, God.
Yeah,
We first in that little studio and shit, though, like everybody in the studio with. Other than that, like,
what they talking about, Max Fanny, though? What they fun and shit?
That man ain't gonna be private, but bid got public. They say that my mama wanna let pay for the film.
Oh yeah, they were like, they say your mama like, well, she didn't want to come.
Yeah, they said she don't want to come.
Yeah, I already told them for but whole family gonna be talking crazy anyway. Like they gonna be like, we don't want no money, nothing. Like they gonna be tripping.
Yeah, you know how.
They just how they shit be,
Yeah. I'm like, damn.
That's why I know he just like, man, he just respect it. He just know how that shit is.
Yeah.
Yeah. I just see what he had going on. I just chill.
I'm pull up on you like tonight or tomorrow or something.
Alright.
Alright, so I can see the part about needing to get drugs and money to, drugs to sell coming in as a co-conspirator statement. The rest of it, you're gonna have to flesh out a little bit more how that is anything more than them just kind of talking about stuff that's already happened and a funeral that's gonna happen, but that isn't, a part of any kind of conspiracy.
Understood, Your Honor. And also, because this came up again on this call, one of the Quay that they mentioned very briefly, there is, I don't know definitively they're talking about this individual, but one of the individuals at Waters Road is Quaytez is his first name, last name Arnold. So they may potentially, in reference of who was at Waters Road with them, be referring to that individual just through context. But number two, a key part of this call that the state wanted to introduce was when, in the state's reading of this call, when they laugh about, I heard that someone got flipped, they flipped a car under by the bridge in the Ville, and then they kind of laugh in a way that's like an inside joke laughter. and Davikion Garlington is one of the individuals charged with Chanel Drink's murder. And so when they make that comment, that specific comment, to answer the court's question, I believe that them laughing and saying that, I don't know. I guess the truth of the matter of that would be that there was someone whose car was flipped in the bill. The state believes they're talking about Chanel Drinks, but it's not saying that he's confessing to that, but it's the fact that they're laughing, saying that I think that the state believes is important in terms of when they make that comment, that reaction that they both have kind of instantaneously is an important contextual detail of how they discuss kind of light reference to something that's eerily similar to the murder of Chanel Drinks. And so that specific portion, the state believes has a non-hearsay purpose, which is really their laughter to that statement. The state does agree in terms of, I know we initially stated, or what we provided was the entire call, but so the state, what I will do, Your Honor, is to provide clarity for both defense counsel and the court, is I would like to, I can by tomorrow at least have the state's proposed time hacks of what we would play so that we can address it tomorrow efficiently.
Okay.
Because I don't want to, if the court permits.
Okay. I'll let you do that.
And does that include addressing the issue concerning that name, Loquay? Again, that gets us into that same issue. While the state says they have a theory on who they believe that person is, who is not Mr. Marquavius Huey, we again are left with this confusing, misleading information concerning Quay again. So I would ask the court to take that into consideration as well. We believe, again, we think that it's confusion.
I mean, that reference was to Lil Quay, and it wasn't to whoever Lil Quay is doing anything wrong. So,
again,
I mean, if you want to come up with some instruction that, I can't give an instruction that says you may hear a reference to a Quay in this call. That's not Marquavius Huey, because I don't know whether it is or not. So, I mean, I can't give that instruction. I'm not sure quite what you want me to give. Hey, a lot of people go by Quay.
Well, I want you to help me out with 403 and how sometimes evidence should be left out if it's confusing and misleading to the extent that it causes a jury that
It may be that part of this is not in the more narrow. So let's talk about that.
Thank you, Judge.
Whenever we come back to that. All right. Remind me.
Yes.
We're reserving argument.
Yeah, we're just gonna, no point arguing if it ends up being two little things that,
Okay, thank you.
yeah, we'll just come back to this one. Sure, but let's find out what they are first. And give me a second. I mean, you can be queuing it up, but I've got to write myself notes so I know why we're coming back.
Yes, Ron.
Okay, ready.
Is going to be 635, PDF page 635, reference number 624.
All right. So what's going to be like the significance
Yes, Your Honor.
of this, and why do y'all think this comes in?
So, Your Honor, this is Davikion Garlington speaking to the caller about the search warrant on Waters Road, and says that Miss D is on them, in the state's theory referencing Detective Viverito.
Okay.
He calls the individual on this call Unk.
Are you having a good time?
To know with this, the topic of this discussion, it's more important than in other situations where someone's like asking for a gun or trying to get drugs, of this individual's relationship with the street gang.
Okay.
If I could add this to one to discuss tomorrow.
Sure. So we can come back to this one.
Yes, Your Honor.
513, we're coming back to in 624, or 523,
523 and
635.
635. Yeah.
And Your Honor, on a similar vein, this is the only other one I see coming up recently. 820, which is PDF page 820, reference number 806. It's the same number, same individual.
So come back to that one.
Yes, Your Honor. Yes, Your Honor. So, Your Honor, the next call is 1079. Excuse me. Is that right? Okay. Yeah. This call's on March 21st, 2022.
I'm just gonna add this before you listen. I just want the court to know that my client, Mr. Stillwell and Mr. Nichols, had been arrested by this time.
All right. Thank you.
And so, Your Honor, in the states, what the state highlighted in this call, just before we play it, is they say that SHIT just came in, and Unfunk, who is defendant Williams' brother, has already pled out on this indictment, just called and told me to pull up. The state believes that they're talking about some type of contraband drugs when they say that it just came in and told them to pull up. The reason the state, I don't definitively know, it's not like I have eyes on Garlington and he goes and picks up a bag of drugs, but it's in the context of other wiretap calls where Garlington is primarily selling Percocets. And so that's why the state wanted to highlight this, because it speaks somewhat in code and also references another co-conspirator when he says the shit just came in, Unfunk just called and told me to pull up, which is like in reference to going to get it from another co-conspirator, at least in the state's theory.
Okay.
This is a very brief portion. We're going to start at 26 seconds and end at 31 seconds.
No, they can't tell me.
For the record, we're starting at 23 seconds now.
Hey, man, what is that? I said, shit, they came in. Long for they can't tell you. Don't tell them pull up that now. He get 9 times.
Any argument on this one?
Yes.
Okay.
Once again, too long on guesses and too short on facts. It's just an assumption. It's the fact-free world of conjecture.
Their argument is a reasonable inference that could be made by a jury from this evidence. That's all that's really required, so. How about an evidentiary objection? Any of those?
Relevance 401.
Relevant to their argument that part of what the enterprise engaged in was illegal drug sales. So overruled.
Your Honor, the next call is PDF page 1124, reference number 1109. This is on March 21st. The key part of this call, and the state's intending to play 17 seconds to 19 seconds, is the individual says, "I'm trying to get the weed, answer your FaceTime," which again goes to the state's theory of before and after or during criminal activity, they utilize FaceTimes so that what is discussed can't be recorded and phone logs or phone references are not tracked.
Yo.
For the record, Your Honor, we're starting at 14 seconds.
What is it? Yeah. Okay. Kind of done. I'm trying to complete. What is it? D? Yeah. All right, so I'm calling you. Matter of fact, I'm still FaceTime. Right here, spot. I'm still FaceTime. Two. All right.
And Your Honor, we ended up playing it till 29 seconds. I think that was a typo. It was meant to be 17 seconds to 29 seconds.
Any argument?
Same thing. It's speculation. Trying to get some weed that could be to smoke a doobie over a steak that night.
Could be. Nonetheless, evidentially speaking, it is admissible under the co-conspirator exception.
Well, and remember now, Mr. Stillwell and Mr. Nichols are incarcerated. So if somebody else is out there trying to do something on their own, it may not be admissible against Mr. Stillwell.
I'm just not buying the concept that just because somebody is in jail, they're no longer a part of an ongoing conspiracy. I mean, in an ideal world, that might be true. But there's, that'll, y'all have to, if you want to make that argument or present evidence that it all stops them.
Well, it presumptively stops them upon arrest. I've heard no argument to you or any proffered facts that either one of these gentlemen continued to be involved in the drug conspiracy on the outside after their arrest. The presumption is the arrest stops it.
Well, I mean, I guess at least as to Mr. Stillwell, I might need to revisit the whole thing about drugs found in his cell.
But, Your Honor, I was just about to say, because the Harvey rule is in effect,
You're opting out of that.
I am opting out of Mr. Harvey's argument, and I'm opting out of the Harvey rule.
That would be smart of you for this particular argument. So, I mean, he might have something as to Mr. Nichols with regard to this, unless y'all got something that would suggest that it's on, this is something that Mr. Nichols continued to be involved with, because I do think the law is kind of that arrest kind of is a pause on certain things, so.
Your Honor, what we will research for the court is, because this, for example, the call we just played was on March 21st of 2022, certainly both charge counts and overt acts in this indictment in the conspiracy occur after that. as recent, at least in the indictment, as May 9th, 2022, where the search was at the home of defendant Williams with drugs and firearms. With all that said, also you have incidents that happened in both Fulton County Jail and three-way calls from individuals in prison. So it's the state's theory.
Do any of those involve Mr. Nichols?
Well, it's the state's contention that because of the Rico conspiracy, they do, because he hasn't avowed himself or disavowed the conspiracy. In this specific conspiracy, as alleged by the state, and believes the evidence will come in, shows that this conspiracy operates quite easily and effectively within both prison and jail, as in the attempted murder of Mr. Rayshawn Bennett, as in some of these happened since the case has been in trial. So the state, we will find research on this specific issue, because I am aware of what the court's referencing in terms of if you had a drug conspiracy case and one individual, not a Rico, not a gang camp, just two individuals in a drug conspiracy, there's some case law about if one of them went to prison or jail, was confined, you couldn't hold their separate one unless they were somehow communicating. I think the Rico and street gang changes that calculus, but I'll find case law to back that up, Your Honor.
Thank you.
The next call that we will be going to is PDF page 1155 and reference number 1140. This is a March 21st, 2022 call. The state, this is not confirmed, but the gang experts believe that this is Unfunk, Mr. Greer, who was referenced, but it's not confirmed. But what is said and why the state wanted to play this is everything's dying down. So, and then it has a couple expletives. It basically says these people think that they're up. We are supposed to get out of town for a little, I'm telling you, man. And it's the state's belief that in the world of criminal street gangs being up, there's references, not specifically on this wiretap on this call, but from APD gang detectives about like, it's like a scoreboard, or so being up on someone is like we have more murders or more violent acts on you. So we have the dominance over you. And so that's why the state wants to play this when it says everything's dying down after there's been murders of YSL members, they've been shooting up Waters Road. And then it says we're supposed to get out of town. That's why the state wanted to play this part.
Okay.
And 14 seconds through 46 seconds is the portion the state tends to play. We'll probably start at the beginning just to give some context around it.
One thing to it, yeah, that shit, FaceTime shit was tripping. I said, let me know, I'm gonna put up. Oh yeah, you already know, man. We just gotta move, everything dying down, so now these fuck niggas think that, yeah. That's how we're going on. Everything dying down. Yeah. Yeah, like you know how they go. That's why we pulled goddamn went out of town for a little minute, bro. These niggas they want me to pay for this shit. Nobody want to put in their money to pay, bro. For real. Anybody else pay to put in to pay for the fucking Airbnb? I'm like, that's the part.
There's no doubt that Mr. Garlington is a talker, but not everything he says furthers the conspiracy. And this is just two people being chatty. And it's just idle chatter and not in furtherance of any aspect of this conspiracy.
All right. gonna admit that under the co-conspirator exception, appears that they're still contemplating future moves as a group. What's our next one?
Our next one is reference number 1163, PDF page number 1181. And the part that the state wants to introduce is Garlington is speaking with DeMarco Boyer, whose nickname is Little Co. And so he says, I'm fixing to have Co pull up and give him that stick.
Okay.
And so the state wanted to just highlight the exchange of firearms and reference to firearms in their own. So the state will play it. We're playing the entire call. I believe it's quite short.
Where you at? I'm finna have Cody pull up, get on that, the stick. Alright.
All right.
When I have this Excel spreadsheet on my computer, I think I read one above. That's what Deputy Hilton was. Who he was speaking with is a female, but he's talking about Mr. Boyer, as in he's telling this female he's gonna have Mr. Boyer get his stick.
All right. That seems to be covered under co-conspirator exception. Are there other objections besides that?
Again, Mr. Nichols is incarcerated, telling somebody else is gonna pull up with a stick. I don't see how that is in the course of it.
Well, we're waiting on that one.
Okay,
Thank
so
you.
just reserve my objection, please.
Thank you.
Your Honor,
Yes.
I mean, I'll email it to the court and everyone, but it's, I think United States versus Harding, Harding. It's 2024 United States Appeal, Lexus 14995. It's decided June 20th of this year. It's in Division 3A as in Elisa. And it does say what Mr. Harvey said. Generally, a co-conspirator participation in a conspiracy ends with his arrest.
Oh, yeah, no, I know that's the general rule. What I'm looking for law on is what are the exceptions? When is that not the case? So, yeah, no, I thank you. That maybe wasn't clear about that. I'm looking for what I just said. Okay.
So, Your Honor, the next call is reference number 1205, PDF page 1224. And this is Garlington talking with Mr. Wright, whose street name is WOT, where Mr. Garlington and Mr. Watt, like you've heard reference about 30 deep, it comes up with Mr. Copeland. And so they were 30 deep. Mr. Garlington was 30 deep and then became YSL, but that is who he's speaking with. And the state is going to be playing 904 to 1032.
Oh, yeah.
Okay, he got a lawyer, right?
They broke. Gonna get out of boy, man. Say he gonna get burned. And the other nigga, he gonna get out of it. Like,
Man, the shot was blown, got locked up for it.
nah, they were when they said they looking for him. I didn't talk to them the other day. Back yesterday, 2 days ago.
The shot was low, like, oh, hell,
Yeah, but he keep calling. Hey, you be bro. What the hell going on? All that shit, but I don't know.
Damn.
He called you, say what's going on? Man, he called me everybody. He did drunk. Yeah. What they did, man? Yeah, I know it. But you know how this shit, you brother, nigga don't have to ride. Nigga know you gonna get through it, but I just know nigga like, well, nigga ain't did that, bro. Man, I don't know. You don't know, they don't have no choice. They be saying you don't have no choice. Like, yeah. You see what I'm saying? In real life, like, you got no choice. You gotta go hell on these for rides until they let you go. Yeah. I said, I'm going gonna be good. I'm gonna put my name in that shit. Oh, yeah.
And Your Honor, we're gonna back up just a little bit. We just started a couple seconds before when the context for this portion to start. And for the record, we're gonna start at 8 minutes and 35 seconds.
To the house tomorrow. Oh, she came by herself. Oh, okay. So she had came. Yeah, I had my phone on. I went to see the news and shit. Oh, okay. Yeah, what? Oh. He did make something in the house? Who? Who you with already did that first? When? I said, if he still make something in the house, who you? Oh, yeah. Okay. He got a lawyer, right? They say, bro, gonna get out of boy, man. Say he gonna get Brian. And the other nigga, he gonna get out of it, like. Man, the shot was closed, got locked deep, got out of the foot. Nah, they were the one they said they looking for. I didn't talk to them the other day. Back yesterday, 2 days ago. The shot was low, like, oh, damn, yeah, but he keep calling. Hey, B, bro. What the hell going on? All that shit, but I don't know. Damn. He called you, say what's going on? Man, he called me everybody. He did drunk. Yeah. But they did that. Yeah, I know it. But you know how this shit, you brother, nigga don't have to ride. Nigga know you gonna get through it, but I just know nigga like, well, nigga ain't did that, bro. Man, I don't know. You don't have no choice. They be saying you don't have no choice. Like, yeah. You see what I'm saying? In real life, like, you got no choice. You gotta go hell on these for rides until they let you go. Yeah. I said, I'm going to be good. I'm gonna put my name in that shit. Oh, hell no, I was there. Yeah.
That's the portion, Your Honor. It's the state's theory that when he says bro's gonna give all the boys money, he is referring to defendant Williams. That's a common theme that the state has put forth argument on to the court, that's why the state wanted to include this in terms of when criminal street gang activity occurs, trying to further the conspiracy through that. That's a common argument the court's heard about the relevancy of that, Your Honor. So, Your Honor, they when they mention
1 in 7 people in America are living with food insecurity.
Who was charged with one individual charged with shelterless murder? He had a clothing line like Keep America Slime, and so that when they say this comes up a couple times in the wiretap, and it's going to come up kind of frequently because you're going to hear later about YFN and some Goodfellas, which is another street gang members, attacked Miles' father when he was in Fulton County Jail. But people reference him in terms of Little Shorty who sells the clothes. And so it shows familiarity with, and he was not on this date of March 22nd. I do not believe he was not arrested yet. And so that was the portions that the state, and then they say he's just gonna have to ride, don't put my name in this. And at the time, of course, Mr. Garlington is not arrested either for this. And so we're gonna get in a couple calls where he gets nervous when he hears about stuff on the news or the warrant out, because when he's making these calls, he's obviously not incarcerated.
So, in regards to the second part of that call, it is Mr. Garlington giving his retrospective version of events and talking about what Mr. Farley is feeling, to apparently the state believes this is Mr. Wright. I don't know how this kind of, again, idle chatter about what Mr. Farley is going through and everything else, while the state might believe that's relevant, it still has to fall under a hearsay exception. And this sort of chatter is now furthering the conspiracy. And so, I mean, I see the state's argument about relevance, but again, they need that hook to fit through a hearsay exception.
Is there some other meaning to when he says he's just gonna have to ride? Y'all have a theory as to what that means? I'm so sorry. Are we just gonna have to ride with a theory as to what they mean by that?
So the state's theory in this context is essentially he's gonna have to ride it out. Like when Farley he didn't have any criminal history to my knowledge before this happened. And so what ends up happening is when he goes to Fulton County Jail and some of these calls that come up, they try to get protection for him. And so they're basically like, he needs to ride it out, not tell on anyone, not panic, and just stay the course. That's what I believe that they're talking about.
All right.
That's the state's theory.
Okay, I mean, I would think, I thought that might be what the theory was, but that sounds like them still sort of, here's our plan for how we're gonna handle this as we, the enterprise, go through it.
Well, the way I hear it, Your Honor, respectfully, is that Garlington may opine like that's what Mr. Farley needs to do, but there's no directive or plan to convey that to Mr. Farley, as far as I can see in this call. So, I mean, even if it does mean he needs to ride it out, I mean, that anyone can say, oh, someone else just needs to be patient, you need to ride it out, you need to let the criminal justice system run its course. But in, the state, I think, is making a huge jump from that to, oh, he needs to be quiet. And
Well, right after that, he says, don't put my name in that.
well, and that's to me,
So, I mean,
that's Mr. Garlington's.
this may not be that every indicted and unindicted member of the co-conspirator is on, a Zoom call saying, all right, here's how we're gonna do this. But everybody doesn't have to know every little thing everybody's doing under the law. So I'm gonna admit this under that exception. Yes, sir.
I believe I heard a reference to what I think is my name, and I would ask the court to exclude that.
Yes, can y'all redact that out, please? Yes.
And of course, we'll do as the court instructs. We do have a point at which we believe later on in trial that we would be presenting evidence that we would ask the court's permission, bring it up to the court as Judge Glanville had instructed us to do so. There will be a point where we believe it will become necessary to bring up the fact that there has been representation of multiple persons, or an attempt to provide representation for multiple persons in YSL. By Mr. Steele, he is correct that we were instructed not to bring up his name before we brought the issue before the court so that the court hears it. the court may or may not be aware that prior to trial actually starting with this jury, we had a hearing on whether or not Mr. Steele should not be qualified to represent a party in this case. The judge determined that there was not a conflict, but also noted that the case may be that the state has the right to present that evidence, but before we do, we have to bring it to the court's attention and litigate that issue.
All right, well, at this point, y'all haven't done that yet, so excise is new.
Yes.
And when do you expect to get to that point?
Because this is, I believe, the second reference that we've had, there will be multiple times. We didn't want to bring it in, like piecemeal here, piecemeal there. So it would be later on, like at the latter part of the trial, around the time that we present the drinks murder, that we would be bringing up Mr. Steele's representation. If the court permit, we're going to bring it to the court's attention.
Okay, so I don't know, obviously we'll need some more non-jury days at some point besides what we've had this week to sort out other issues that we know are on the horizon. But for right now, let's just take his name out.
Yes, Your Honor.
And let's leave his name out of that, no matter what my ultimate ruling is on why it might ultimately be relevant. All right?
Yes.
Okay. Why don't we stop and take a restroom break? Be back at 3. That gives everybody about 12 minutes.
Yes, Your Honor.
Let's celebrate the red, white, and you. It's the Rooms to Go Labor Day sale. Shop the hottest new pieces, the coolest new rooms.
The following after that is reference number 1739, PDF page 1762, which is a March 28th, 2022 call. And on that call, Your Honor, is Little Co. Mr. Boyer, who asked Demikion Garlington that he needs to come get the blick, and he told Garlington to take it home with him. And then Garlington replies that he has his fire at the house, but he just didn't bring it with him. And then they asked for an address. Again, that's what the portion of this wiretap call the state wants to play, to show, one, how they reference
firearms and two, how firearms get exchanged between members. Quatarius Zachary, which the state, I mean, not the state, the court has heard about when we went through his interview, and other evidence will come out. He gets arrested with a firearm that ballistically gets connected with the shooting of 1007 Hill Street, which was the mother of Mr. Bennett's mother's home. It's common, but the state doesn't actually believe that Mr. Zachary himself was part of that. So it shows that firearms get switched, exchanged, passed between both YSL gang members and sometimes other or allied street gangs. And so again, that's why the state wants to play this. It's a brief portion.
Okay, and it's to show how they reference guns, like the terms they use to reference the guns, flick and fire, and that they exchange them amongst each other and allied people. Do I need to listen to that, or?
The state does not believe you have to, Your Honor,
Okay.
unless you want to.
I don't want to unless I have to, because I think it goes a lot more quickly if we don't have to cue it up, listen. If I need to, I will.
Well, before I argue about the admissibility, it says the entire call, so is the state representing that is the subject matter of the entire call, or they're gonna limit the excerpt to that discussion?
That is correct, Mr. Sharp. And I will get, I don't believe it's a very long call. It's 2 minutes, 52 seconds. I will get more clarity, but it's where you need to come over and get this blick. I'm geeked up at the studio. I told you to take the blick back. And then they mentioned running into someone, and I don't have that blick on, and I got the fire at the house, and they talk about sending the address. So I'll find when that time is, but that's the statements that we're referencing.
Okay, well.
I can just listen to it. I'll just listen.
Yes, Your Honor.
We'll find out.
Yo. Yeah. Come here.
Hello?
Yeah.
Yeah, bro.
Where?
Bro, you need to come over here and get blick, bro.
I'm at, where the hell you at?
I keep going at the same way you just left, man. That shit got to blow me, bro. I told you to take the blick on with you, man. It don't matter, bro.
Yeah, you right, bro.
Yeah, you go for they got to go to him, bro. Like, come on, bro. Brother, oh, that's man. That shit about to blow me, man. Like,
Yeah, it wasn't even that. It was like, the shit, I'm like, man, shit, I went cold, I ain't gonna remember, but I heard this on TV, but it man, that's good.
Anytime nigga ain't got that blick on him, that was some shit out there, be like, no, man.
Yeah.
Way right there, bro. No blick, bro. You can go get that blick, but you can take that blick home, bro. You take when you stay home, son, bro.
Nah, I got to fight down. I just told they ain't bring that, but like, you got to see me there.
Come to it, just go and get look here, I'm finna pull in right now. You know, I gotta have one of you to drop in.
Yeah.
But I'm pulling up right now.
So like, on the GPS, what is happening?
Type in, look here, see they come to a look here out. Cause it is after look here out. You feel me? I'm literally 2 minutes away from the studio right now. As soon as I get there, I can drop in.
Alright, well, I'm gonna head up and get my car.
Type in the cave. Yeah, type in down the cave. Fuck, I don't know this shit, you know. Fine time. That shit gone too. Type.
Your Honor, this there's a call that was shared in the initial Dropbox co-conspirator link. It's 1760, which is 2 minutes before this call that should have been on this XL because it's directly related to why he's talking about getting the firearm. And so that call, I would like to play 1760, and the state also would like to introduce that call. And to give a little context with this is from consulting with APD gang detectives who investigated this in real time. Mr. Garlington coincidentally goes to a hotel in Cobb County, and there's a rival gang member whose street name is Little Lizzie, who, after the murder of Mr. McMiller and Mr. Ford, there's a whole lot of, I don't know the way to put it, just vile, disrespectful social media posts about, like, there's a picture of individuals X'd out next to their child, and say now they don't have a father. Things of that nature that escalates significantly the animosity and violence. And so Little Blizzy, that murder was never solved, but he is in the far end of the spectrum of sending out very disrespectful social media posts after that double homicide. And so the significance, and we'll play this call right now, of Mr. Garlington running into him. He didn't have a firearm on him, and so he just randomly runs into him in a hotel. And so this call we just played when he's talking about coming to get the gun is basically they're like, you need to keep that gun on you because there's a lot going on. So I wanted to play and apologize for not having this on here. That was just an error. The 1760, which is at 1:56 a.m. The call we just played was at 1:58 a.m. So I'm going to play PDF page 1760, reference number 1736. Thank you.
What is it? Hey, so crazy how different kind and tell you I just ran to the nigga, bro. For real? Hey, that what you talking about? No. I thought he said something else. What he said? Nah, him. The nigga, the blizzard. What he say? Shit. He seen him turn his head. For real? On DVD, he seen like, I tried to look at him, like, turn this shit. What he saying like? Man, we at the same hotel. Right now. Right now, be safe for us, man. I know that, bro. I ain't got my. The nigga say it's real. J. Carl say he finna shoot a video. He want us to see the video. What about the studio? Yeah, I'm finna meet them back up here, but he just come back outside. But leave them to give you a gun, son. Which one? My side? The one with the chest in? The one with it. Hold on, let me calm down.
So that is 1760, Your Honor. The state, well, if the court would like to hear 1762, which is, but we heard 1760, which I think gives a lot more clarity to. Yeah. Yes, Your Honor. So the state feels that both of those are in furtherance of the conspiracy because Demikion Garlington, a YSL street gang member, is calling and notifying people about who he ran into, a rival gang member, and trying to, he actually makes multiple calls that we're not going to play all of these, where he's trying to get, and he references this interaction in the hotel.
So, Your Honor, Mr. Garlington has a long criminal history. I don't know when the state feels that Mr. Garlington met Mr. Stillwell, but Mr. Garlington was allegedly, or he pled guilty to committing crimes before Mr. Stillwell knew him, before Mr. Williams knew him, and he has plenty ability to commit crimes without being associated with anyone here. And at some point, we're just, again, I understand that being arrested doesn't absolutely close you off from a conspiracy. I think it's fair to say there is a presumption, but I understand it's not absolute. I understand it's not that simple. But at some point, we are in a situation where we have two gentlemen in jail, and Mr. Garlington going about his criminal life. And that is, whether he's associated with other people or not, or whether the state is alleging that he's associated with other people, everything that Mr. Garlington chooses to do and every crime that he chooses to commit in his day-to-day life is not involve my client, does not involve Mr. Nichols, and the state is at this point trying to bring in Mr. Garlington's chatter about picking up guns and selling drugs and all these things that Mr. Garlington's been doing for years, and somehow impute them on two gentlemen that are in jail. And that's my concern. I understand that it's not an absolute that my client is no longer part of a conspiracy, but I'm not, the state is theorizing, but there has to be a difference between Mr. Garlington's everyday criminality and criminality that is specific to an alleged association with YSL. And that's my concern, is at this point, we're just throwing in his everyday criminality, and it's making my client, who is associated with him through social media and other things, and that's just a fact that I'm gonna have to deal with. But at some point, it's creating character issues and prejudicing the defense of my client.
Your Honor, if the state may.
Yeah, who's the other person that,
So,
whether, who the other person is?
yes, it is DeMarco Boyer,
Oh, right, you said that.
who is affiliated with an allied gang, PDE. And so, with that said, also in reference, when defendant Stillwell is arrested, there's a contraband phone. He's still speaking with Demekion Garland. And the state indicted and believes that both Demekion Garland and Shannon Stillwell, 11 days before this, murdered Chanel Drinks, a YFN member. And this little Blizzy is, again, someone in that same rival gang. So Demekion Garlington trying to get a firearm to take out a rival opposition is in furtherance of the criminal conspiracy that the state alleges defendant Stillwell is still a part of, and all the defendants are, before, during, and after this March 28th call when it's made. So it's not just Mr. Garlington on his own, it's in furtherance of that criminal street gang, which has to retaliate for a double homicide that they are blatantly disrespecting on social media, and that in the world of criminal street gangs cannot be tolerated and has to be handled with more violence. And so that's why the state's theory that this is in direct furtherance of the criminal conspiracy, because if Garlington got a firearm and shot or murdered little Blizzy, that would be in furtherance of the criminal street gang. So him trying to get that firearm is helping move that needle forward in terms of the conspiracy.
These two both appear to meet the 801D2E exception. What's our next statement?
Our next statement is 1759. Or sorry, reference number 1759, PDF page 1782, which is March 28, 2022. I think Mr. Harvey likes to. The reference numbers, the state likes the PDF page numbers, so I'll do both.
Well, thanks, because the court likes the reference numbers too.
And then that's the state's preference, is the reference numbers. So we're gonna play, I think it's only 57 seconds of the call.
57 seconds of it, but I don't think they're starting yet. I don't think they've said that yet.
Yeah, the total call is 57 seconds, Your Honor. And Mr. Garlington is calling. I want to make sure I read. So the state believes the voice sounds like Unfunk Quantavious Greer. Not 100% confirmed. That's who the state believes he's talking with. And so the state, and what is said is Garlington is told that a YFN member wants to talk to him, and the other party tells Garlington to call them when they are all around. So this is in the context of, there's a lot of back and forth, and there's also, so long story short, it's how they are referencing and speaking about a rival gang, YFN, the state wants to highlight, and we'll play that now.
Yo, what's up, man? What the hell? I heard it downtown. But I said everyone went on last day in comments when I want to talk to you. They want to talk to me? Yeah, you know the one I told you about that one I used to do before though. Yeah. Yeah, they tell me comment, bro. Tell me comment, bro. I like that, bro. So I just want to talk, bro. We'll shit out that my shit, bro. I heard they best purpose. But this shit got me out of my saying. Yeah. Yeah, I just let it listen to talk shit. Yeah. So you call them, we all around, so you know what I'm saying? Yeah. That what I'm doing. I'm calling we all around. So on my side, I'll let you come. All right.
And so, Your Honor, the state doesn't have, I don't know exactly what this YFN member wants to speak with, but the fact that this is being set up and kind of having like a mediator to talk between them is relevant to show, because this constantly through this trial from 2015 to now, the jury is hearing and the state is explaining, you know, shootings, murders between these two groups. And so the fact that he needs to get a mediator to speak with someone from that establishes there's an us and a them. And so whether he actually had this call or not, what exactly they want to talk about, it kind of has a non-hearsay purpose in terms of the fact that he's setting this up this way. He can't just call this person one-on-one or go meet them. That's the main purpose of it, or why the state wants to introduce it.
Sorry, not being offered in such a way that it would even be hearsay. So it's admitted, I mean, alternatively, it could be a co-conspirator statement, but it does not appear to be hearsay to begin with. All right, what's next?
Next, Your Honor, is reference number 1767, PDF page 1789, which is a March 28, 2022 call. The state believes that the other individual on the phone he goes by the nickname of Dad and is a 30 deep gang member. And what is discussed is Garlington tells, his name is Mr. Britty, tells Mr. Britty that he stayed in Cobb the night before because he ran into an op and didn't have anything on him. So it kind of gives context to wanting to get the blick. He specifically calls Little Blizzy an op in this call. And again, it explains and gives clarity to how Garlington views Little Blizzy. And the state will hear when Detective DiVerito is discussing this part of the case about this inflammatory social media that Little Blizzy posted, how YSL members viewed him and why Garlington running into him is significant. Because if there's an us, there's and a them, that is a key part of this. So the state will play this call now. It's 1 minute and 10 seconds, Your Honor, so the state will play it in entirety.
Hello, Eddie. What's going on, bro? Pulling up in the hood. Right in the hood. Yeah. What you got going? Shit, man. I just woke up. You said you gotta go where, Nick? After you back, so you gotta go somewhere.
No, man, I got down in the hotel in Carl last night, right?
Yeah.
I run to
No.
I ain't got nothing on me. I'm like, shit, I'm gonna go out here. I know everybody out here.
Yeah.
Yeah, you go to the gym, like, yeah, buddy saying, turn the head. You know, he see you and turn the head. Yeah, you don't even know he got you down bad.
Oh, definitely.
Yeah, what are you gonna do? Yeah, right here, let's keep them moochie. Okay.
Stopped it at 1 minute and 5 seconds. There's only 5 seconds left, but it was that portion about Garlington speaking about what I just described, Your Honor. The state wants to, is why the state wants to introduce it.
All right, that seems to fall essentially under the same things we've been talking about. I'll admit that as a, under the co-conspirator exception.
Your Honor, the next call is reference number.
Yes, sir.
And I'm sorry,
No, not at all.
I want to ask the court that if I can have a continuing objection to these phone calls that reference something out in the world when Mr. Nichols is incarcerated. And again, I understand that we kind of reserved that issue, but I don't want to go on to the next one without saying, hey, I've still got this objection up.
Sure, and I mean, he doesn't get out again, right? I mean, he's not, so.
Unless you're gonna let him out for, I'll take him to dinner tonight.
Okay. So, I understand that it's, that it covers all of these from the time he's in until, I mean, who knows how many we're gonna have till now, I guess, if they come up with some other call, but, all right.
So, Your Honor, this next call, reference number 1869, PDF page 1893.
Okay.
This is Denikion Garlington speaking with DeMarco Boyer.
Okay.
I actually think that this call, the strongest reason for its admissibility is a non-hearsay purpose, because they're discussing, we got to take Buddy's name off that. Because if that individual, they're talking about a song where someone's name's in it, and they literally say, if he gets whacked, you know that stuff's going to come down on us. I don't need nobody trying to put a Rico on me. And then references putting their names in the song. And so a big thing of this, not the thing, but an aspect of this case from opening until present day is the state using social media, using lyrics, using just statements of co-conspirators. And the state and defense have different theories of what those things mean. But the fact that they're conscious of what they say and put in a song in direct relation to something that can happen in the real world or in the streets, so to speak, is very relevant, because the state's theory is that there is kind of a double entendre, or it's kind of like a line of how far can you push it in terms of street gang members know what you're talking about, but the police can't use it against you. And so with all that said, I wanted to play this part for really a non-hearsay purpose, whether they put that, I don't actually have the said song, but like whether they released that song or didn't put his name in, is the fact that they're consciously, and by discussing that and thinking through that, is important and is the state's minds a non-hearsay purpose.
So, yeah. I'm trying to sit there anyway. Dave? It's a that. But I ain't gonna lie, we got to talk. We got to take Buddy Man out that shit up. We got to, bro. You know, if bro fuck around and get wet, you know that shit come down a lot. Yeah. Type shit, man, they already. And then young dudes so hot on the east side right now, too. They're like, I don't know if they're trying to build a case against niggas or what, like, you feel me right now. But they had it fuck, like they jerking out to laying nigga down, like nigga. That's why they was so high up down script on the day, got on Glenwood on the day. That's why they was been around with that. So that come 2 days, so I ain't need nobody trying to get no Rico on me. Mm-hmm. You know what I mean? So it's like,
Yeah, like the estimate.
so it's also shit like I'm just too like thinking, look at was even saying the same thing. Like shit, I was gonna tell y'all niggas this shit, bro. That y'all probably say bro name, bro, cause his ass gonna be gone. You think y'all drop the song now, he get gone by somebody else on Twitter. We drop the song later. I mean, you know what I mean? Yeah, I feel right. We just gonna take the nigga name like this shit. We just gonna take, like, I ain't even scared. Shit still pop. You feel me? Just on smart shit, cause I don't think them niggas will put a song like that. But at least switch it up. You feel me? Mm-hmm. Yeah, even if we say that, like, we don't be like you fit deep. You ain't share. Say something different. Like, you feel Shell got that. Shell don't want that. Or some shit. You know, I don't give a fuck. We say the same thing. I don't give a fuck about saying name. But I don't want you, you know what I mean? Tasha, you.
And Your Honor, you heard they're talking when they say the line has something to do with Shell. And it's the state that they're talking about, Shell Cal, who comes up repeatedly in this case, and is someone that YSL has been trying. There's violence from January of 2015 until this call was made March 29th, 2022. And so Shell Cal's name comes up repeatedly throughout. And some of the social media I referenced about disrespect when individuals get murdered, Shell Cal's social media posts are a part of that. That will come up in Chamel Drinks. So that's why the state wanted to play this portion, is really for the non-hearsay purpose that they are thinking through. They discuss the lyrics and how it can impact literally the police, because they're like, if he gets killed, it's going to come back on us. They're going to look at us. So we need to take his name out. So that's why the state wanted to introduce that.
Okay. Anything from the defense?
Well, if I am not mistaken, it's being offered as non-hearsay. And if it's offered as non-hearsay, it's not offered for the truth of the matter asserted, and therefore there needs to be an instruction saying, you can't consider this conversation for the truth of the matter asserted.
So I am a little puzzled as to that issue.
And Your Honor, I guess I started with there's really two arguments, and sometimes there is, in terms of if they put this individual, it's also a co-conspirator statement in terms of they're strategically trying to make sure that they don't get in trouble for releasing a song when they're trying to kill this individual. So the fact that he's like, you could probably take his name out, that does move the ball forward in terms of the conspiracy, because the conspiracy does not want to get caught. Because if it does, it can't continue as well. And so there's that aspect of this as well, in terms of they're strategizing about, like, it's a good line, but it's too, when he gets murdered, or if he gets murdered, it's going to create a police involvement with us. And he's trying to get him to not release the public song with his name in it, with the purpose to further the conspiracy by not getting caught. So there is it's not an either or. Sometimes there can be multiple purposes or theories, and I think that's appropriate with this specific call.
Okay.
I think they're saying, let's not commit a crime. I mean,
I think they're saying, let's not provide easy evidence to inculpate ourselves. I'm going to admit that under the co-conspirator exception. There's no crime in releasing a song, as y'all have all argued. What's our next statement?
Next statement is reference number 1974, PDF page 1999. And this call from March 30th. there's reference, so again, this call references Blizzy, who I've discussed with the court earlier. And it also references there's a reference to a street name of Haiti, which is a Leviathan member, Mr. Higgins, that is also connected with the killing of Mr. McMillan and Mr. Ford. And so we're going to play this entire call. And on this call, Garlington also references, he says SB, talking about Defendant Stillwell's cousin, who's a female, was followed by a black Durango. There is the murder of McMillan, Mr. McMillan, Mr. Ford is not solved, but the black Durango, there's referencing to it in a couple wiretaps because they believe that that vehicle was involved and is associated with the rival gang. And also, Garlington tells the other party again, he's mentioning running into Little Blizzy, he didn't have the fire on him, and he gives the address of where he was staying that night.
Yeah, then Quay called me like, see, I trying to follow her, yo. You said what? Quay, if you could say I trying to follow her? Nah, hell nah. She sound like a nigga trying to follow her. She said a black car, but black truck. So I think she trying to say the black. I mean, you can't. I mean the black Durango. And see like the nanas and shit like that. I like, it's just like at the door, it was outside. So like, they left for you. Nah, she wasn't paying attention. So she get in the car. I mean, when she walked the gun there, like, he's like, no. So then she get in the car. Like, the nigga put in front of her car. She got the bag up. She had the motherfucker follow her from the door. Like, she ran to the roadblock. She was on the back street of the river there. She ran to the roadblock. They did a U-turn. Damn, that's a fool right there. That might be Buddy though. You know, Buddy used to track me on DM talking about, I'm gonna find out where you stay at and shit. Yeah. So I ain't trying to talk to her. It might be Buddy. Did they say they had the ring on? Hey, I don't know. Hey, you know who I just ran into, bro? He called up, bro. I told him to pay this shit the other day, bro. Who? Man, I ain't had no file on. I just ran into the nigga Little Blizzard, bro. Oh, somebody just got them on the phone the other night. Bro. That what he was in? No, I don't know. I was at both checking in the hotel. Like I was going upstairs. Yeah, with the whole he was checking in. I see the what that's on TV, but then turned their head so fast, bro. Damn, they still been playing out there? Yeah, I don't know. Damn. What hotel it was? He was somewhere in car, bro. I gotta get the name of that shit. He talked to the clerk like he know it. Damn, man, come on, fuck with me. Ain't pay money now? Nah, he ain't pay money. I'm gonna call. Man, I don't. It's man. What street is on? I had that motherfucker. But I got the address right here. That shit will call. $3380 Overton Park Drive, Southwest. Yeah, wait, another paper. We ain't gonna go play right now. They be cleaning up at 3380. The one that called the police on your house last time, 3380. So you said 33 what? 3380. Yeah. Overton Park Drive. OVERTON West Drive. OV Park Drive. Overton Park Drive. Yeah, south east 11. Yeah, right on that side of Cumberland. I mean, Cumberland, Engine Park. Yeah. We got him. He might be playing right there.
they got spent in him hating like two other niggas. Got spent and ran or something.
For real? Yeah, I ain't even know that. Bring Papa, yeah.
So your Honor, also, the black Durango was associated with the shooting at Waters Road on March 16th. I misspoke when saying the Ford McMiller double homicide. So Deputy Holtz, actually, it's connected with both the murder of Mr. McMiller, Mr. Ford, and the Waters Road shooting. So I want to clarify that. And also, Your Honor, there's a reference of getting the address where an op was the night before we got him. And so this discusses past events of running into a rival gang member at the hotel, but also references be on the lookout for this black Durango, and also has references for future conspiracy activities of getting addresses of opposition gang members. The state does not know exactly who Mr. Garlington is speaking with, but a conspiracy can be furthered because Garlington gaining this information and discussing this still furthers the criminal street gang conspiracy. I wanted to give all that information to the court.
Thank you.
Borrow Mr. Harvey's term about nested hearsay. From my understanding, this call, and I'm going by the state's notes as well, this call has Garlington relaying what SB's cousin, that would be my client's cousin, said to him about being followed. That would be hearsay within hearsay. So I'd ask that anything involving what was said by my client's cousin be redacted.
This again has been put in writing in the state's brief. I want to find it, but in terms of co-conspirator statements, you do not have to search through time to, like, there is not a double hearsay exception or objection that if something is a co-conspirator statement in furtherance, the statement, the speaker making it, you don't have to determine if they have personal knowledge or not personal knowledge of it, because the statement itself is in furtherance of the conspiracy. And I will find the case law to back that up, but the state has briefed that issue in writing in the initial, and I'll find the date, kind of general co-conspirator brief. And
I'm not sure if I follow what you're trying to say right now.
I was distinguishing when Mr. Sharp was objecting to double hearsay or nested hearsay.
Yes.
And I wanted to find the specific. So if the state gives me, not the state, no, if the court gives me a brief moment, I actually brought this motion with me and can't currently find it, but it's directly on point to this issue.
Well, there's a difference between personal knowledge and nested hearsay. So let's not go down the wrong track.
We can go down both, Mr. Harvey. And find the right answer.
Let's stay focused on the issues at hand and not back and forth with each other.
Me and Mr. Harvey get along well, Your Honor. Let me see. Can we?
Let me ask you this, which might make it not necessary. Are you offering that hearsay that's within this statement for its truth?
The
part about the, I guess, girl saying that a Durango followed her.
It's the fact that,
or that Mr. Stillwell's cousin says that whomever said that a Durango followed them.
Your Honor, it is for them being them discussing the black Durango, because the state doesn't have any additional evidence that like that black Durango on this date and time was outside about to shoot someone. So it's the fact that they're discussing the vehicle that's connected with the murder and the Waters Road shooting, the fact that he's discussing in opposition terms Little Blizzy, and the fact that they are discussing whether they actually got the address and found the opposition member or not. The fact that they are discussing that is relevant in and of itself. And the state doesn't have, so the state is not intending to say, aha, 5 hours later, they went to someone's house and shot them. So it's the fact that they're discussing all of these things, which is really a non-hearsay purpose.
Okay, well,
To answer the court's question, Your Honor.
not sure to answer the question, but what I take from that is that your answer would be, no, we're not offering the nested part to establish that somebody actually followed her in a black Durango. Is that true?
Yeah, correct. We're
Okay,
not.
in which case that is not hearsay. And the rest of it comes in under the co-conspirator exception.
Well, whether the state's intent is to do that or not, it asserts a fact that is harmful for my client if believed. I don't know how the jury is necessarily supposed to compartmentalize, oh, well, this is not being offered for the truth of the matter asserted. It seems to me that it would be, if it's not offered to prove that, I mean, this is important evidence if believed against my client, because it suggests that my client is responsible for Shamal drinks, and therefore other people are now following my client's family members. So it's not just a little deal in my mind.
Okay.
And so it seems to me that even if the argument is we're not offering it for the truth of the matter asserted, it would fail a 403 test, because what does it matter really that my clients, for the purpose that they're claiming, that they're discussing the goings-ons of the quote-unquote opposition, what does it really matter other than to just make reference to my client? What does it really matter that my client's cousin is the one that said it? If we want to redact my client's SB's cousin from that, that's fine. I don't have a
All
problem.
right, why don't we just do that? It'll make the whole thing easier.
Judge, the importance of that part is that whether there was actually a black Durango following anybody or not, there was their belief that they were. There was this belief that was shared among them. The reason that this is a co-conspirator statement is that they are participating in the enterprise by apprising one another of things that could harm them.
Yeah, the appraisal part's not the issue. Do you lose any of that by taking out the two? I mean, if they even say SB's cousin,
We could listen to that part again to ensure that we are accurately asserting what is being said. But our belief is that the fact that that something they believe is endangering one of their members' families is something that is causing them to act. Yes. So that is the reason that we believe that remains inside that statement, because by making one another aware of a potential danger, whether it exists or
family
not.
member of one of their co-conspirators.
Yes.
I mean, honestly, I don't see how. I think it's a bit of a. It's not that it's a stretch, it's that you'd have to pile one building block on another to get to, if some bad guy out there is following a cousin of your client, that must mean your client has committed some crime against a member of that group. I mean, yes, it could be, put together that way, but it's hardly like, oh, A equals B, therefore C.
Well,
It just isn't.
this conversation occurs days after a murder occurred that my client is charged with.
I understand.
And I think the state knows exactly why they want to get it in, and that's why they want to keep the reference to my client's cousin saying it. It's, they want the truth of the matter, sir, to be brought in front of the jury. And if their interest is just that they're aware, then there's no reason that they're aware that people are following, and there's no reason to include SB's cousin. They could just put they could just put Quay or whatever. Quay said this, and they don't lose anything.
Okay, so what they lose is then they're just saying, hey, some random person is getting followed by a Durango. And that's what they don't want to lose.
In the context of the conversation, no, I don't think it's just some random person. It's obviously someone they're associated with and concerned about because they're talking about it. So it's not just a random person.
All right, I can listen to it again, which I don't need to do here. I will just circle back and listen to this one again.
And Your Honor, I'd also point out that Mr. Shard is making a 403 argument, and given that there's nothing about this belief on their part that is substantially more prejudicial than probative of the fact that they believe that this Durango is following a member or a family member of one of their group, and that belief is being shared, and in order that they do something, that they act accordingly. They're participating in the enterprise by.
Yeah, that's not his argument. His argument is that because the Durango is following a relative of Mr. Stillwell, that must mean that Mr. Stillwell committed the crime against their group a few days before, which is what I'm saying is a whole lot of building blocks having to be stacked on top of each other. But I will take another listen.
And it's not that it must mean that, it's that it's evidence of that.
And I mean, if it is, it is. I mean, that's why the state puts up one case, and if the defense chooses, they put up another case, and in between there, they cross-examine all of the state's witnesses so that all of the different theories can get presented before the jury that all the sides want presented, and they can sort out what they believe to be the facts and apply those facts to the law.
But I'm not going to be cross-examining Demekian Garlington, and I'm not going to be cross-examining Quay.
No, but you are going to make a closing statement, I would suspect. So, I mean, it's how trials work. So I will take another look, and I'll let y'all know. Thank you, Judge. All right.
Your Honor, the next call we're turning to is reference number 2119, PDF page 2145. This is on April 1st of 2022. And the state, this is defendant Stillwell on a contraband phone talking to Demekian Garlington about a number of things. He discusses, so there's a lot of discussion about the Chanel Drinks murder where we're going to ask to play this entire call, but defendant Stillwell says he doesn't know why Miles got out of the car, referencing Miles Farley. And Miles Farley was arrested April 1st as well, which is the same day that this call was made. He also discusses we had referenced this some earlier, but they're kind of like they're trying to decipher how Farley is handling getting arrested on this serious charge of murder. But there's a lot discussed, but we would like to play it, but it mentions a number of different relevant circumstances to include defendant Stillwell tells Garland that it's ugly and he needs him. He also states, and they discuss, Garlington tells defendant Stillwell that Dolly said Thug's not talking to anybody, and Garlington says it should be funny. He should be funny and post free Wyeth and Lucci, because at the same time, Mr. Bennett is also in the Fulton County Jail. And so also defendant Stillwell tells Garlington that the gunpowder test will come back clean, so he isn't tripping, which the state believes in reference to the vehicles utilized in the murder of Chanel Drinks. So the state's going to play this call from the beginning to the end.
What's up, bro? What's up? What's up, what? What's up, man? Man, shit right here to the new boy. Huh? I said right here to the new young boy. They got going, right?
Yeah, you know, I can hit you on that other phone. Shit, I'm fucking on them motherfuckers.
For real? Are you on? Oh, this another one?
No, it's
Yeah, everything.
Yeah.
Yeah, bro. I know. I ain't felt about that time. I think that's what you right. That's what I ain't felt.
I really coach fun, so I just like, yeah. I can't, man. I'm fucking tripping on that motherfucker.
For real, man.
Yeah. I had to say one shit. I'm gonna go straight to the grandma house. I had to stay out that motherfucker.
Yeah. But she told me that I moved to upstairs.
Yeah.
Running like what's going on with that?
No, I'm with Fred.
You a Fred?
Yeah.
Oh, yeah, for sure. Yeah.
And they do it for
They don't. Yeah, damn. Somebody said, T-Rock was up there with you, bro?
Yeah, T-Rock was downstairs with me.
Yeah, because somebody asked me in the hood, they're like, bro down over it, but T-Rock, I ain't know T-Rock locked up.
Yeah. What the hell going on? What the hell, what's up with Tuck, man? What the hell you doing? Talk crazy like this.
What you think?
Just talk crazy like, man, all this shit.
You talking crazy right now?
Nah, it's about me, talking about my shit.
But I ain't on TV, I ain't heard of that.
Yeah, it's a lot of this shit. So, bro.
Yeah.
Had me blow.
They blow?
Had me blow.
Oh, yeah. I ain't talk to him. That's the only person I be talking to either now.
Yeah.
Like, he be asking like what's going on. I'm like, yeah, I don't know.
Yeah. What the hell?
Like, damn, bro. Like,
everything smooth though.
Yeah, I know it. I already know that.
They just got they on mild.
Yeah.
Cause I don't know why the fuck he even got the car.
Yeah, that's what I'm saying. Like, that's what I'm telling folks. I'm like, shit, but they locked up for like, they just saying like, I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. They gonna assume that like, y'all ain't did, ain't killing though.
That's what I keep telling you. Lil, I keep telling him like, just chill. Like, I know. I'm like, this ain't nothing, bro. Like, they just doing that cut. They seen that they got gas. It's like, they chill. You see what I'm saying?
Yeah. Yeah, man. I'm telling, I keep telling my other things, shit like this, bro. Just like, you like, bro, I'm feeling fucking cat. Listen, bro, no. Just tell me what you want to talk, bro. Like,
man, listen, bro, I told Baba, I'm like, hey, tell buddy, do the same thing I did when I went in there. So for, hey, I want to see my lawyer. I'm going to say nothing now to me. So he got the same shit. Don't say not one word.
Yeah.
What they trying to portray or what they say, man, don't say shit.
Yeah. I ain't know that. I'm like, I do. But I say something like, hey, bro. Like, him, I just called. Like, you heard? I'm like, yeah, nah. I'm like, shit, I know. I'm like, I keep contact through. You know what I'm saying? They folk. I ain't turning on the phone. I'm like, he don't understand that anyway, though.
Yeah, I ain't doing that anyway.
Yeah, I already know you. I already know it.
I need you.
I know. I already know that. I told her like
I told her like tell him I need 1,000, but anything in between, she got that.
Oh no, yeah. Same thing with that first night.
Yeah.
I know, like, when I talked to one call today, and she told me like, be patient, cause she had that talk to she DM me.
Oh, what?
Yeah. She like, and just tell them like, and no, ain't gonna leave them folk like that. Like, they tell them just be patient. It was a day, good morning.
Yeah.
Yeah. And it's him to take it, bro. Work out.
I already know that part. I just like I know like how that go. You know what I'm saying? I ain't really tripping on that. I ain't tripping. Like I've been just trying to keep buddy calm. You know what I'm saying?
Yeah, do that. Okay. Yeah, bro.
I don't really be liking that coaching and shit. That shit have me all out. Like,
yeah, I talk the phone. Like, I talk the phone. I been with bro. Like, we at in the daytime. Like, oh, what's up with Clay? Like, what the hell? I don't know Clay on the phone saying something. Like, I don't know if he on shit. Like, he told the world, like, and tell buddy got them get money, bro. We did that shit for him. He paid, come on. Yeah, that was phone call. He like, bro, stay on, chill out, man.
I ain't know that about it.
Yeah, them guys downstairs. He like, yeah, they were gonna see him on Main say that. So I'm like, I know they ain't even upstairs. I'm like, he got access to them.
Hell, he ain't one there like that. I don't think he said no shit like that.
Yeah. But then, I thought, that was saying, I'm like, what the hell is that? Farming.
Who?
She told him they, I'm like, farming.
Okay.
Yeah. She really kind of told me to be careful out with the porn. They would the little thing. I ran to the boy little bitch by myself.
Yeah?
Yeah, I ran to him. Yeah. I ran to him by myself. Like, that's what we be showing up when I see you turn the head.
Yeah.
Like, yeah. But like, we was on live and code on no buddy on my page and shit. So I don't know who chose out the video chat like, bro, when I ain't run. I say, you run, you damn sure turn your head, man.
Huh?
I say, nah, you say you run, you damn sure turn your head when you sing it, though.
Yeah.
I ain't knowing which one. I'm like, listen, bro, what's going on? Like, before all this shit, like, shout out to straight.
Yeah.
I'm like, shit, but you know what's going on? Like, yeah, bro, ain't no problem with you, bro, with everybody. I'm like, listen, bro, you know I had this shit here, bro. I had this shit go like, I'm like, yo, I speak to everything. I'm like, shit, that ain't going on no more, bro. I'm like, yeah, they gonna give me. I'm like, man, I ain't recording right now. I told Corey, be quiet.
Yeah.
Yeah, well, now they been made a video about an hour ago at the stove with sticks and shit. Like, yeah, I'm like, 3 hours.
Man, they on some, man. So I be saying stay away from that. That's police shit.
Yeah, man.
That's 12 shit. I ain't with that.
Yeah. Damn, man.
It's all good. Everything.
I know that. So you still like LA right now? Like, they want to take no picking?
I ain't really saying him. But I ain't really saying that. You just really like, just chill, be patient. Like, same thing White tell you.
Yeah. Okay. So I ain't been around like they gotta say
Do it.
Talking to nobody. Like they say they like rain, never say that nigga hurt like that, but that nigga hurt. Like that shit.
I thought they said the one he really, really fucked with.
Yeah, I know it. Yeah, man. Everyone cut your ass too, bro.
Yeah.
Yeah.
What the hell? Who? I heard.
Yeah. No, I could be funny with free wife and those.
Yeah.
Yeah. Right.
They had to tell me that shit. I'm like, man, I'm gonna help 12 in here.
Man, what? Phone, so they call him, phone, we surround line, and they say he running the police and the gang shit. Like, they say, like, he got police, like, he probably don't know, but, like, they watch his ass.
Yeah.
Yeah, like, they bumped his ass.
Mm-hmm.
Yeah. And they said they were gonna do it. We got 12 for them over some shit.
Yeah.
Yeah.
Yeah, that I don't trip. Yeah, I don't tell the boy about this shit. I was like, man, he be like, you ain't gotta tell me. I already know. Like, I'm gonna be got tripping.
Yeah.
Like on the other one, like he was like, man, you know, I stand on more. Man, I fuck with but I don't want the other. I think about that on female shit.
Wait, yeah, I ain't on DV. I ain't heard nothing about that though. But I ain't even talk. I'm trying to talk to him. I talked to him like same night y'all got locked up.
You gotta add when you call boy, you gotta add boy what he say, cause I can't really say like, cause she won't really just tell me like in detail, but she just beating around the book. I really be telling her, man, shut the fuck up.
Yeah.
On that woman, cause I ain't going for that strand.
Yeah. You know I got you, bro. I had the long trying to get down. I didn't have to take care of that down. I know I got you, bro. You got to get down the whole time, bro. I trying to have this shit like I'm knowing like the need this shit like.
Yeah.
I ain't got you, bro. I'm here with you, man.
Yeah, sure.
Yeah, I'm trying to get.
I ain't gonna, you know, like, I ain't gonna, well, I say a word, but like, cause like, I don't even have to say your name. Like, she know who I be talking about. I don't be telling nobody else, but I ain't gonna hit you on that motherfucker, like, ever. You know what I'm saying? But, you know, everything really good, though.
Yeah. Yeah, I'm like, I heard that. I'm like, what the fuck?
Yeah.
I'm like, that shit was fast there.
Yeah.
Yeah, that's all it is, just a song.
I don't know, like, when they got down, go to whacking down, going got down, them, you know, they gun powder for rings, all this shit up.
Yeah.
Don't come back clean, you see what I'm saying? So I ain't tripping on that.
Uh-huh.
Yeah.
Yeah, bro.
What the hell Trim on? You're still in the
Yeah. I just read that.
You know what's what?
Yeah.
Who? Yo, folk.
Yeah. I was looking at that.
Yeah.
Yeah, you got out of time, man. We're gonna get ready to come back. I was gonna lie with that.
Yeah. You talk all night. That's a night crazy, bro.
Yeah, I said all day.
But that'd be crazy.
I'm telling I'm like, you on the cell phone, like probably be over like what not. She's like, what? You ain't think you tell on me? I'm like, yeah, man.
She can't. I don't even text my ass back no more.
I should be telling like on tap and shit.
Yeah, I don't even use phones. That's crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, man. I got you.
Right.
I know you too.
Your Honor, the call is complete. So I don't know if defense has any objections to this call. I think the court understands the state's position of this. We've named it as a co-conspirator statement in furtherance.
Your Honor. Carter Matthews again on behalf of Mr. Mark Labius Healy. So there was a reference in this call again to a quay. And our position, as we stated earlier, is that it's a 403 issue that we're making at this time, as we did previously. We believe that this is a confusion, creates a confusion of the issues with this, the use of the name Quay constantly. The jury has heard the name Quay in this trial up to this point. They have heard it. We did file a motion for severance at a previous date. It was denied. I'd like to renew our request for severance on this issue for the record. And on the basis, again, it's a 403 issue with respect to this word name Quay being repeatedly used. I think I've heard it like 3 times, at least in these series of calls. So on that basis, Your Honor, we believe that a 403, and if the court is unwilling to grant the severance under the 403, confusion of issues, confusion of evidence, I would ask this court to, again, reserve the issue to allow us to craft an appropriate 105 instruction that will address this issue.
All right.
Thank you, Your Honor.
Is there any response right now from the state?
Detective Vitorino will clear up, I think, quite clearly that this is in reference to Defendant Nichols, not Defendant Huey, because when they're referencing, they're upset that on a phone call, Mr. Nichols says we did this for Big Bro, talking about the state's theory, Defendant Williams, in terms of we did it, the murder of Chanel Drinks, who was, I've already described kind of the back and forth, but the testimony and the state's theory, so there won't be any argument at closing, and Detective Vitorino, who's going to be introducing these wiretap calls, she will make crystal clear who that Quay is referenced on the call. So there won't be any confusion.
Okay, well, that'll cure any potential confusion, so make sure that she does that. All right.
Am I correct in my belief that the state intends to introduce this whole call?
Sounds like it.
Okay, so my immediate concern is around 5 minutes and 30 seconds. Mr. Garlington is talking at this point, not my client. I talked to Funk. I've been with bruh, and he had me on FaceTime, like, yo, what's up with Quay? And then Quay on the phone saying something like, I don't know if he on this SHIT, like, he told Rel, like, tell buddy, god dang, get a lawyer, bruh. We did that SHIT for him. He paid, you know what I'm saying? Okay, so we got Garlington having talked to Unfunk, who is Mr. Greer, who supposedly, and I'm trying to put it together, it's not completely clear, but he talks to someone named Rel, and then somehow this comes back to Quay, who, I think that the state is asserting is Mr. Nichols. So we have like a game of telephone with 4 different steps leading to Garlington then saying this to my client. And then it should be noted, my client does not tacitly acknowledge, or I think we've been using tacit admission. He says that doesn't sound right. So it's not that. He pushes back, and it's just nested hearsay times 4 in what Mr. Garlington's saying. So I have a real problem with that, because obviously that is someone who is not testifying to my knowledge, the originator of this, and it's passed around a few times, and it goes directly to my client's innocence or guilt. And it's, this little bit in itself strongly suggests that my client is guilty, because the implication is Quay said we did this for Buddy. I'm not concerned about the for Buddy part. I'm more concerned about the we did this part. So that's a major flag right there. And it's nested hearsay. It's 403, any probative value that could come from this, other than its value as hearsay with 4 steps, is negligible. Clearly they could get out the facts that they're talking about attorneys without going into that segment right there that is extremely prejudicial to my client. So that's my first objection. I would also object that these other conversations about attorneys just generally are not furthering any conspiracy. But But those don't, there's an extra level of concern regarding the time around 5:30.
All right, well, I think we've discussed the issue of attorneys potentially being provided by leaders already, and my ruling would be the same with regard to that. What is the state's response to the issue of it being hearsay inside of hearsay, that we did this part?
So, Your Honor, that this is a classic co-conspirator statement. This is one co-conspirator from providing reassurance to, providing direction to, and promoting cohesiveness with another co-conspirator in furtherance of the conspiracy itself, which is YSL, the criminal street gang.
Right, but back up into this isn't just him, this is somebody else saying that, right? And
yeah,
Mr. Shard at least is saying that Mr. Stillwell pushes back on the assertion. And this was a lot, so I might have to hear it again, but
Yes, Your Honor.
if that's accurate, then that seems like that couldn't be, oh yeah, this is an adoptive admission.
Your Honor, a couple things. One, defendant Stillwell is quite upset that Mr. Nichols made that. So the fact that Garlington and defendant Stillwell are discussing that, they need to know what's said on jail calls. They need to know who's talking to the police. They need to know who may fold, and they need to keep tabs on both members in jail and outside. So when they referenced earlier about Mr. Farley and how is he doing, and he needs, so.
Yeah, that's not the part that they're raising, that Mr. Sharp's raising an issue about right now.
You're specifically discussing, Your Honor, so defendant Nichols saying we killed him for bro, and Mr. Sharp saying cannot come in this conversation with his client, Mr. Garlington, when they're discussing the intimate details of the murder that they did for bro. The state feels that, and this is why, and I will find the case on this, their conversation, Garlington and Shan Stillwell, in all its contents, whether they knew this personally, they knew this from like that statement, their conversation is fostering cohesion amongst them because they both agree he shouldn't be saying that on the phone. And that's where co-conspirator 801D2E is a little bit unique, where this nested hearsay, if it's deemed a statement in furtherance of the conspiracy, keeping abreast of the crime, future, past and or future activities, fostering cohesion among street gang members, that type of analysis is incorrect. If you deem that statement and them discussing what one of the other co-defendants did in the murder that the state indicted both defendant Stillwell and Mr. Nichols with, and Mr. Garlington with, I think it is classic co-conspirator hearsay, which takes aside Mr. Sharp's objection. The nested hearsay is not an appropriate analysis if you deem that statement, which the state believes it is co-conspirator statement. That's the state's position on this nested double hearsay.
We really need to see your case law.
Yes, Your Honor.
I think that's just incorrect statement.
I'd be surprised that it just makes what would otherwise be a valid evidentiary objection disappear. Maybe it is.
And so if it's hearsay, and I'd have to, like the court, I have to hear that little part again, but if they're saying that it's hearsay, that Mr. Nichols' statement about what they did is hearsay, and Mr. Stillwell is on the call.
Right.
Right?
Yeah, this is Garlington and Stillwell.
Right. And when he says that his client pushes back, he's not saying we didn't kill him.
No, I don't know. Let's hear it again. There was a lot to unpack with this. Maybe it would have been better to take this in sections.
He says that doesn't sound right. And to push back, you don't need to repeat everything that was said and said, no, that's wrong, no, that's wrong, no, that's wrong.
Well, I mean, it could have been in reference to the, whatever the arrangements were for an attorney. I don't know exactly where that came.
But let's start with the proposition that it's Garlington and Shannon. Garlington is talking about talking to Funk, who had him on FaceTime. And that's what Mr. Nichols allegedly told Rel, which was repeated by Funk to Garlington. So, I mean, we're talking about layers upon layers. And this is the classic nested here. So you can't just say if one state, the first conversation comes in, everything else in the world comes in. It doesn't.
Well, I don't think it does, but the state seems to think that there's law that says it does, so we're gonna let them find that. And if you just want to point me to wherever the original motion is or response is, I could read it on my own, but I mean, that's easier than you trying to find it right now.
Your Honor, I'm trying to find both the date and the motion itself.
Them that be patient. It was a date. Good morning.
Yeah.
Yeah. And it's them do paper, bro. Bro, I got it.
Well, no, that part, I just like, I don't know like how that go. You know what I'm saying? I ain't really tripping on that. I ain't tripping. Like, I've been just trying to keep buddy calm. You know what I'm saying?
Yeah, do that. Okay. Yeah, bro.
I don't really be liking that coachman shit. That shit got me all out. Like,
yeah, I talk the phone. Like, I down bro. Like, yeah, in the daytime, like, oh, what's up with Clay? Like, what the hell? I don't know, Clay on the phone saying something. Like, I don't know if he on shit. Like, he told Real, like, and tell buddy got that good lawyer, bro. We did that shit for him. He paid, you know what I'm saying? Yeah, that was phone call. He like, bro, stay at home, chill out, man.
nah, I ain't know about that.
Yeah, them guys downstairs, he like, yeah, they was upstairs on rain to say nothing. So I'm like, I know they ain't even upstairs.
Can you play just maybe the last 30 seconds again?
Yeah, I don't know, Clay on the phone saying something. Like, I don't know if he on shit. Like, he told Real, like, and tell buddy got that good lawyer, bro. We did that shit for him. He paid, you know what I'm saying? Yeah, that was phone call.
Keep going.
Oh, he like, bro, stay at home, chill out, man.
Nah, I ain't know about that.
Yeah, them guys downstairs, he like, yeah, they was upstairs on rain to say nothing. So I'm like, I know they ain't even upstairs. I'm like, and he got assets to them.
Hell nah, he ain't wasn't there like that. I don't think he said that shit like that though.
Yeah. And then I thought, what the hell is he saying? Farm.
Okay, thank you.
So, Your Honor, our position is that what he is pushing back against, and it's the context of that statement that is the most important, because they're trying to relay to keep someone calm, and that they were talking to Onfunk, who was a co-defendant who pled guilty in this case, and they are alarmed at the fact that another member is potentially on a jail call saying that we did that for bruh. And that's the point at which Shannon is pushing back, saying like, what? Right. Like, I can't believe that. And then he's like, nah, you know, he didn't do that. And the other guy says, you know, I don't know, he could have been on a cell phone or what, but that's what I heard him say. So his alarm isn't at, he's lying on me. His alarm is that, and this is what we would argue, of course, anyone can make their own arguments at trial, but we believe that this is what the evidence shows, that the alarm is at the fact that this person on a jail phone is saying something highly incriminating to them and sharing this information between them all. And the alarm in itself is evidence of the fact that this whole conversation is in furtherance of that conspiracy, which is the enterprise that is YSL and the criminal street gang activity of YSL. So none of it is hearsay when all of it is statements of a co-conspirator. It is their reaction to their
It's still
belief.
hearsay, even if it's a statement of
I'm
a
sorry,
co-conspirator.
it's a
So I mean,
perception.
at some point y'all are saying, this isn't hearsay because we're not offering it for the truth. So I know
I'm
that's not
sorry,
what you
I was-
meant,
I
but let's
was-
try to keep the terminology clear.
You're right. You're very, very right.
And I didn't mean to interrupt you. I just want to make clear, like, we
You're
got
right, that's
we have got
important.
to all be clear about what we are saying and what we mean by what we're saying.
Your Honor is absolutely
All
right.
right.
And so that is, we are saying that there is an exception,
Right.
and that this is the exception that it falls under.
Okay. All right. And so again, I understand that the conversation between Stillwell and Garlington might come in under a co-conspirator exception to hearsay. The thing that is at issue is the relaying of Nichols allegedly having said, whatever he said, you need to line up a lawyer or whatever, you need to pay for it because we did this for Buddy.
Right.
And the concern is that either that part is being offered for its truth, or even if it's not, that certainly once the jury hears that, they take that as evidence that it is true.
Understood. So
Do I understand you to be arguing that that part of that is also co-conspirator exception, or no?
I need to address that part of it. So one moment, Your Honor.
Sure. Do I have the argument correct that y'all are propounding?
Well, yes. And if, while they're gathering this, Mr. Atkins is listening, I hope. So can I respond? If we break this down, here's what the sentences were. Garlington says, I talked to Funk. I've been with bruh. I don't know who that is. And he, I don't know whether that refers to Funk or bruh. And he had me on FaceTime. That could refer to either one of those people. What's up with Quay? That's the next question, next statement. Why the hell? I don't know. Quay on the phone saying something. Like, I don't know if he, and again, we got a he on shit. I don't know who the he is referring to. He told Rel, that's another person, that's another layer.
That's somebody who's listening, that's not somebody who's talking. So anyway, and also, can I get this portion of what you've written down as a transcript? Because it would be most helpful.
I can give you what we have, yes.
Okay,
But I'm breaking it down because now we're on the third person. He told, I don't know.
Okay, but that's a listener, so keep going.
Okay, he told Rel, and I don't know who Rel is, and I don't know whether Rel told Funk, and I don't know whether Rel told Rel. We have no clue.
Okay, but keep going.
Okay, he told Rel, like, tell Buddy, god dang, get a lawyer, bruh. We did that shit for him, he paid, And then Garlington says, you know what I'm saying, to Garfield. To Shannon, I'm sorry. And Shannon says, what? And Garlington says, yeah, that's what Funk told me. He was like, tell homie to chill out, bro. Now who's homie? And who's the bruh? I mean, we have so many layers of unknown, and nested hearsay is exactly that. That's the whole point.
Okay, so the short answer is yes, I've done your argument correct in terms of understanding what it is you're arguing.
Yes.
Your Honor, to be clear, because I may not articulate this well, my position of what Mr. Harvey just broke down, at least what these statements they say.
Yeah.
Funk, who was a defendant in this case, and the state believes was a YSL street gang member, him telling Garlington that Nichols needs to chill. Funk isn't charged with the murder of Chanel Drink, so him telling him that is a statement in furtherance of the conspiracy.
Nichols needs to chill. That's not what I'm concerned about.
Yes, Your Honor.
Okay.
But
I'm concerned about the Funk saying, Garlington saying Funk told him that Nichols said he needs to pay. We did this for him, so he needs to get us the lawyer.
And Your Honor, the state feels.
But send it to Rel.
It doesn't matter who he said it to. It sounds like Funk heard it regardless.
No.
Do I have that part wrong?
I think you do, because he said it to Rel. Rel said it to somebody else.
Nichols said it to Rel.
Well,
Allegedly. Allegedly, I understand.
Yes. And then Rel to Funk, then Funk to Garlington. So that's 4 layers at least.
So, Your Honor, two things is, and the court may just disagree with my argument, which in terms of.
What I like is some law.
Yes, Your Honor. So the case law I was referencing earlier, I will find this date, but there's no double hearsay issue. The statements are admissible without a showing of the declarant's personal knowledge. And I may have been off kilter where I was thinking of, this is what I was thinking of when I referenced to the court, that there's not double hearsay in this statement, is that under, and I will just cite to this motion because the court can read this, but I will find the date. But the state's position is that it is co-conspirator, it is in furtherance, like the fact that Garlington is concerned or receives this information, that Nichols made that statement.
I understand that part. I
Yes,
agree
Your
with that part.
So the kernel, that part in the middle.
You understand what my concern
I
is, Ms.
do.
Love. You seem to understand it before, and I'm sure Mr. Atkins understands it too. He's just too busy looking up trying to find the law. Go ahead.
That kernel in the middle, that Funk said, Nichols tells somebody, we did this for bro. Nichols saying, we did this for bro. Nichols saying, we did this for bro. I'll start out by saying, at best or worst, whichever way you want to look at it, Nichols is implicating himself and not Shannon necessarily. He hadn't said Shannon did anything. He's saying, me and somebody else did this for bro. So that's to start there as to Mr. Sharp's argument that it necessarily implicates Shannon, who has to push back. Number 2, Funk being a co-defendant of Mr. Nichols and a co-conspirator of Mr. Nichols, relaying what Mr. Nichols told to him. Whether or not Mr. Nichols said it or not, it's statements that Funk is asserting Mr. Nichols gave to him, even though it's a statement against the penal interest of Mr. Nichols. The reliability of the statement, the statement itself being the hearsay issue, we believe is dealt with in that it would be Mr. Nichols, a co-conspirator of Funk, relaying something in confidence to Funk, or saying something in confidence to somebody else who he considers a person reliable enough to share something that inculpatory with. Ompunk is not trying to harm Mr. Nichols, so he's not going out and lying on Mr. Nichols. He's sharing this information in an effort to help Mr. Nichols, get him to shut up and stop talking. They all are trying to get him to stop talking. So in terms of the reliability of the information, nobody here has any reason to share inaccurate information. It only furthers their purposes to be truthful about what's happening so that they can further protect themselves and inoculate themselves from any harm coming from this man talking. So the harms and dangers of hearsay that are normally present when, the whole reason it's kept out is, we don't know if it's true or not, are handled and dealt with by the circumstantial, I hate to use this, guarantees of trustworthiness given that are present in the way that this statement comes about. It's told in a way, it's relayed in a way that indicates it's shared in order to help, not to harm Mr. Nichols, to help all of them and keep them safe. So it's layered co-conspirator hearsay, if you will, but that first relaying of information, the declarant, Mr. Nichols, saying it to Ompunk, it would be definitely a statement against penal interest. But Mr. Greer, who is Ompunk, sharing that information is a co-conspirator statement, which we believe gets us past this idea that this is nested hearsay. And as far as the 403 argument that is being made, in order for it to be so unduly prejudicial as to permit its exclusion, it would have to lure the fact finder into declaring guilt on a ground different from proof specific to the offense charged. And that just doesn't exist here. So we don't believe that they have met, and by they, I mean the opponents of this information coming in, they have not met their burden of showing that this statement from Ompunk regarding Nichols telling on himself, and basically Nichols trying to get help for himself, like bro needs to pay for a lawyer. We did it for him. We don't believe.
Hey, no, sir, Mr. Harvey, stop right now. Stop right now. Stop right now. Mr. Harvey, sit down. I am not going to have you interrupt court. You may object in just a moment. We will get to your objection in a moment. Go ahead.
Thank you, Your Honor. There has been no showing that this information is so substantially more prejudicial than probative that it should permit the exclusion of what we believe is obviously relevant evidence.
Okay, thank you. Mr. Harvey, your objection. I don't even understand that to be what.
In the waiverhood, every delivery is a treat.
By waiver, something minty? Of course.
What she said, but I understood her to be talking about what was being said within the context of this conversation we just listened to.
Your Honor, just.
Yes.
Go ahead.
I'm gonna listen to it again. Offline, not in court.
Your Honor, this is where I'm at with this. Just because the state says something is so doesn't make it so.
I understand.
And the state is saying, oh, well, this was done in furtherance of the conspiracy. This was done in furtherance of the conspiracy. The whole point of the hearsay rules, and I understand that the confrontation clause might not be implicated here, but the hearsay rules, the whole point of the hearsay rules is you get to see who's saying it, know what their basis is, you get to cross-examine them, they come to court, etc. And the problem here is the state is just sitting here saying, oh, well, clearly Mr. Unfunk did this to further the conspiracy and click. How do we know? How does she know? Maybe Unfunk, I'm not saying this is the case, but what if Unfunk was involved? Unfunk would have every reason to shift responsibility to other people. What about the next line in the hearsay ladder that we have? We don't know what people's motivations are. And just because the state says, well, their motivation was to do this or do that, she's not inside Unfunk's head. She's not inside Rel's head. So I reject that their argument that they can just label things as hearsay exceptions and it makes it so.
Well, I understand that. I take what everybody says as your argument in support of your position. I don't accept it as fact. It's an argument. I hear the counter argument. Sometimes I hear a lot more counter arguments back and forth after that. And then I make a determination about whether our evidence rules permit this particular evidence. The point of the hearsay rules and all of the evidence rules is so that to the extent the court can help it, only trustworthy information gets before the jury. And that's what we're trying to sort out here. So I understand that the stakes are high. I think that this might be a good time to break for the day. I will re-listen to this. Mr. Atkins, if you can find, either the date that I can find the motion or the case law itself, just send that to Ms. Firstfield. She'll send it on to me. Okay.
And I will try to get the court and send to Mr. Atkins what I read to the court as the transcript of
That would be great. I appreciate that. Thank you. All right. I know that y'all are all gonna hate to hear this, but sometime during the day tomorrow, and I don't know when, and I don't know how long it's gonna be, people are gonna come in to work on what hopefully will be a fix to the sound issues we seem to have a lot of last week. And there are a couple of other things going on that the court needs to deal with as well, not with regard to this case, just in terms of scheduling tomorrow. It's going to be quite a challenge to figure out when we might actually be able to get here and use the courtroom for any, amount of time that will be worthwhile. And so we are not going to have a court day tomorrow. Y'all may have other cases to deal with, but to the extent you don't, please, continue to work on this case. We still have a lot of non-jury work to do. I think we did a good job this week of getting to the things that will be coming up in the next several weeks. So thank y'all, everybody, for working hard on that. And we're going to have to circle back on, the stuff that is still facing us in this wiretap and some other things. I understand the state is going to get witness 61 through the end, and the information about the exhibits generally coming in with those witnesses to the defense by Monday. And I will see everybody Monday at 8:45. We'll have the jury back with us then. Okay? Anything anybody needs to put on the record before we adjourn for the day?
Good question, Your Honor. We were internally, we wrote down the dates that the court said that we had admin days, but as I was speaking with one of the counsels for defendants, she and I, my team did not have the same recollection, was that there was another period of time that the court had mentioned that we would have the ability to further make these arguments. Was this the only week
This is the only week so far that I know of, that I have established. I mean, I didn't establish this week, but I have not established other dates that we're gonna be in court without a jury. We are gonna have to determine what those are, because we clearly need some more of them. But the dates that I've given to y'all and to the jury so far are dates that the jury will be out and we also will be out. So I'll just have to, I know one of the things I need to do is figure out some more in court for us, but non-jury dates. And I anticipate some of them will be maybe the third or fourth week of September at some point. I'm gonna try to make them either beginning of the week or end of the week, but I don't know yet. So I'll have to get back to everybody on that. All right, anything else?
Just for the record, on that last argument, that you're
Yes.
considering, it's OCGA 24-8-805. That is, what we are traveling under. 20, it's OCGA, official code of Georgia annotated 24-8-805.
Okay, thank you. Yeah. I doubt if many people know that. They just know hearsay within hearsay. But thank you. All right, if there's nothing else, then we are adjourned.